Let's come to order. Please go on the record. I am Commissioner Kimberly W. Duffley, and with me today are Chairs Charlotte A. Mitchell and Commissioner Daniel G. Clodfelter. I now call for hearing docket number EMP-116 sub-0 in the application of Juno Solar for a conditional certificate of public convenience and necessity to construct a 275 megawatt solar facility in Richmond County, North Carolina. On July 12th, 2021, Juno Solar, or applicant, filed the application for a certificate of public convenience and necessity with confidential exhibits and confidential pre-filed testimony of Piper Miller. On July 27th, 2021, the applicant filed revised pre-filed direct testimony of Ms. Miller and a revised site plan, as well as other supplemental confidential exhibits. On July 27, 2021, the public staff filed a notice of completeness as required by Commission Rule R8-63D with respect to the completeness of the application. The notice of completeness also included a motion to stay, which was denied. On August 31st, 2021, the Commission issued an order scheduling hearings, filing of testimony, establishing procedural guidelines, and requiring public notice. On September 1st, 2021, the Commission staff sent a letter to the State Clearinghouse requesting comments on the application. On October 4th, 2021, October 11th, 2021, and October 15th, 2021, the Clearinghouse filed comments on the application. On September 14th, 2021, the applicant filed supplemental direct testimony of Piper Miller. On October 15th, 2021, the applicant filed unredacted copies of both the direct and supplemental testimony of Piper Miller. Finally, on October 19th, 2021, the applicant filed an exhibit entitled Statement of Need, originally filed as confidential with the application and testimony in unredacted form. On October 12th, 2021, Duke Energy Carolinas and Duke Energy Progress jointly filed a petition to intervene, which was allowed. On October 28th, 2021, the public staff filed a motion to cancel public hearing, which was granted. On October 26, 2021, the public staff filed the testimony and exhibits of Dustin Metz, utilities engineer, and the public staff's electric section. On November 9th, 2021, the applicant filed rebuttal testimony and exhibit of Stephen J. Levitas and the rebuttal testimony and confidential attachment A of Piper Miller. In compliance with the State Ethics Act, I remind all members of the panel of our duty to avoid conflicts of interest and inquire at this time as to whether any member has a known conflict of interest with respect to the matter coming before us. Let the record reflect no conflicts were identified. I will now call for appearance of counsel, beginning with the applicant.
Good morning, Madam Chair, members of the Commission. My name is Karen Kimmerite. I'm an attorney with Fox Rothschild in Raleigh, and I'm here on behalf of the applicant, Juno Solar, LLC.
Good morning.
Good morning, Commissioners. I'm Ben Snowden, also with Fox Rothschild, LLC here in Raleigh on behalf of the applicant.
Good morning.
Layla Cummings and Robert Josie, public staff on behalf of the using and consuming public.
Thank you. Good morning. Do the parties have any preliminary matters before we begin?
Yes, we have just one preliminary matter that I wanted to make the Commission aware of. Steve Levitas, we are going to be presenting Mr. Levitas and Ms. Miller as a panel, and they are going to provide their direct and rebuttal testimony at the same time. Mr. Levitas has a flight where he's planning to leave here at 2 o'clock. I've made Ms. Cummings and Mr. Josie aware of that schedule, and we don't think that it's going to be any problem to have him his testimony concluded in time for him to leave for his flight.
Okay, thank you. Any objection? Okay, so allowed. Any other preliminary matters?
No.
Okay, and as with respect to the confidential information.
Sorry. I do have some confidential questions that I believe we can save until the end, but just wanted to make the Commission aware of that.
Okay, thank you. So indicate when you plan to ask your questions with confidential information. Okay, hearing nothing further, you may call your first witness.
I'll begin by calling a panel of Juno Solar's witnesses, and the panel will consist of Piper Miller and Steve Levitas. And I'll begin with Ms. Miller. Ms. Miller, can you state your full name and business address for the record?
Sure. My name is,
Actually, we need to, do you want to swear or affirm both witnesses? Which would you prefer?
Do you have a preference, Ms. Miller?
nope.
Okay, is there a Bible, left hand on the Bible? Why don't we do both witnesses at the same time? Do you solemnly swear to tell that the testimony you're about to give this morning will be the truth, the whole truth, and nothing but the truth? So help you God.
Thank you. Ms. Miller, I'll ask the question again. Can you state by whom you are employed and in what capacity?
Sure. My name is Piper Miller. I am the Vice President of Development for Pine Gate Renewables.
And can you also provide your business address for the record?
Yes, my business address is 130 Roberts Street, Asheville, North Carolina, 28801.
And did you cause to be pre-filed on July the 2nd of 2021, 24 pages of direct testimony in the form of question and answer and exhibits, and specifically exhibits 2.1 and 2.2 and confidential exhibits 1.3 and 1.4?
Yes.
If I were to ask you the same questions that appear in your direct testimony today, would your answers be the same?
Yes.
And did you also cause to be pre-filed on July the 26th of 2021, 24 pages of revised direct testimony in the form of question and answer and exhibit 2.1 and confidential exhibit 2.1A?
Yes.
And if I were to ask you the same questions that appear in your revised direct testimony today, would your answers be the same?
Yes, they would.
And did you also cause to be pre-filed on September the 14th of 2021, 6 pages of supplemental direct testimony in the form of question and answer?
Yes.
And if I were to ask you the same questions that appear in your supplemental direct testimony today, would your answers be the same?
Yes.
And then finally, did you cause to be pre-filed on November the 9th of 2021, 18 pages of rebuttal testimony in the form of question and answer?
Yes, I did.
If I were to ask you the same questions that appear in your rebuttal testimony today, would your answers be the same?
Yes.
At this time, I would move that Ms. Miller's pre-filed direct, revised direct, supplemental direct, and rebuttal testimony be copied into the record as if given orally from the stand, and that the exhibits to her testimony be marked for identification and included in the record.
Any objection? Hearing no objection, the motion's allowed.
And Ms. Miller, do you have a summary of your testimony that you would like to present to the commission at this time?
Yes, I do.
Okay, please go ahead and read it.
My name is Piper Miller, and I am the Vice President of Development for Pine Gate Renewables. Juno Solar is wholly owned by Birch Creek Development and operated in collaboration with Pine Gate Renewables, which is managing the development of Juno Solar's proposed utility-scale solar photovoltaic generating facility. I filed direct testimony and exhibits in this docket on July 12th and 13th, 2021, revised direct testimony and exhibits on July 26th and 27th, 2021, supplemental direct testimony on September 14th, 2021, and rebuttal testimony and exhibits on November 9th, 2021. The purpose of the summary of my testimony is to demonstrate that Juno Solar's conditional CPCN application meets all requirements of North Carolina General Statute 62-110.1 and Commission Rule R8-63, and to explain why the Commission should grant the CPCN with the proposed conditions. In my testimony, I provide information about the 275 megawatt Juno Solar facility in Richmond County, North Carolina, and explain 1, the need for the Juno Solar facility, 2, how the Juno Solar facility with the associated network upgrades will serve the public convenience and necessity, 3, why a conditional CPCN is needed for the facility, and 4, how the conditions to Juno Solar's CPCN application will provide ample protection for the North Carolina ratepayers from unreasonably high network upgrade costs. In my testimony, I emphasize the importance of the Juno Solar application for the state, especially in light of the recent enactment of House Bill 951. Due to the mandate in House Bill 951, there will be a substantial need in North Carolina for new non-carbon emitting generation on the Duke Energy Progress and Duke Energy Carolinas system. I also explain how the requested conditional CPCN provides an appropriate solution for an unintended problem that the Duke Energy FERC Q reform study process created for Juno Solar, a FERC jurisdictional interconnection customer. The Juno Solar site consists of 25 parcels, collectively containing approximately 2,586 acres of land, located along McFarland Road and Green Chapel Church Road in Richmond County. In both my supplemental direct and rebuttal testimony, I provide substantial evidence of the need for the Juno Solar facility. Juno Solar has executed a preliminary term sheet from a large investment-grade retail and wholesale energy supplier in PJM that demonstrates the need for the renewable energy from the facility in the Dominion region of PJM. This term sheet represents equal or greater evidence of need than was deemed sufficient for CPCN approval in several recent proceedings, including those of Fern Solar, Halifax Solar, American Beach Solar, and Sumac Solar. In addition to the executed term sheet with the retail and wholesale energy supplier in PJM, I provide information about the need for the Juno Solar facility in the state and the region. Commercial and industrial demand for clean energy in the PJM market is stronger than ever in the market's history and continues to grow. The year 2020 once again saw strongly increasing C&I demand for renewable energy despite the challenges of the COVID-19 pandemic. Level 10 Energy, which matches renewable energy buyers and sellers and provides insight into nationwide renewable PPA pricing, noted increasing solar PPA prices in PJM over the past 2 years in its Energy PPA Price Index, which has continued into 2021. PJM exhibits the highest solar PPA prices of any organized market in the country, with Level 10 finding a 25th percentile PPA price of $37.50, a price likely driven downward by clustering of PPAs at the discounted AEP Dayton hub and higher at the Dominion hub at which Juno will settle, underscoring the need for renewable energy in the region. Level 10 Vice President of Developer Relations Rob Collier stated in the company's Q4 2020 report, quote, "The convergence of more challenging local and state permitting regimes, prohibitively high grid upgrade costs, and a surge in buyer demand has resulted in a PJM market that is short in project supply, which has in turn led to rising PPA prices," unquote. PJM is expecting peak load growth of 0.3% for the next 10 years and 0.2% over the next 15 years, with a summer forecasted peak of 153,759 megawatts in 2031 and a winter forecasted peak of 135,568 megawatts in 2030 and 2031. In my rebuttal testimony, I provide further information about the need for the facility in light of the enactment of House Bill 951. Due to the mandate in House Bill 951, there will be a substantial need in North Carolina for non-carbon emitting resource generation on the Duke Energy system to serve load to reduce emissions by 70% over 2005 levels by 2030. The 70% decarbonization by 2030 mandate means that a massive amount of solar energy resources will have to be added to Duke Energy's system over the next 9 years. In the Commission's recent order in the Integrated Resource Plan proceeding issued on November 19, 2021, the Commission found Duke Energy's 2020 IRPs that show the amount of solar additions to be at least 9 gigawatts to be adequate for short-term planning purposes. Thus, while the exact amount of solar additions will be determined in the carbon reduction plan to be developed by the Commission next year, it is highly likely that Duke Energy will be adding a minimum of 1 gigawatt of solar per year throughout the next decade. Under House Bill 951, 55% of that amount will be owned by Duke Energy and procured through facility purchases from third parties or by self-development. In addition, there is no size cap on the Duke Energy-owned solar, which means that the least cost mandate of HB 951 will almost certainly drive the procurement of larger facilities with greater economies of scale. There are currently only 5 solar facilities in DEP and DEC's combined interconnection queues with a capacity greater than 150 megawatts. In light of transmission and other development constraints, it is very likely that Juno Solar would be one of the most cost-effective options for Duke Energy to achieve compliance with House Bill 951. Also, in my rebuttal testimony, I provide information that the Juno Solar facility, along with the associated network upgrades, are in the public convenience and necessity. I discussed the substantial benefits that the development of the Juno Solar facility will provide to DEP ratepayers. These benefits distinguish Juno Solar from the other merchant solar projects interconnecting in the Dominion PJM region of North Carolina, about which the Commission has recently expressed concern. In order to wheel its output from its location in DEP territory to PJM, Juno Solar will have to procure point-to-point transmission service across the DEP system. This process is known and transparent, with current and forecast rates being published by Duke Energy periodically. The current rate for firm point-to-point transmission service across the DEP system is $1,738 per megawatt per month. Reserving transmission capacity of 250 megawatts would result in approximately $5.2 million per year in new point-to-point transmission revenues to DEP at current rates. These revenues contribute towards DEP's annual transmission revenue requirement, or ATRR, and are used by DEP to operate, maintain, and upgrade its transmission system. By contributing substantial revenues towards the ATRR, Juno Solar can be expected to reduce the burden for transmission spending that would otherwise ultimately fall on DEP's various load customers. These transmission rates are forecasted by Duke Energy to rise substantially in the coming years. In my rebuttal testimony, I projected that Juno Solar will spend over $275 million on point-to-point transmission over the life of the project. This is the only means by which Juno Solar can deliver power to the PJM marketplace. These costs, not in any way reimbursable by ratepayers, will, under any reasonable assumptions, far exceed the cost of network upgrades which ratepayers might be subject to. Even at the end of a even at the high end of a $4 per megawatt hour levelized cost of transmission, Juno Solar's projected contribution of point-to-point transmission revenues to DEP still exceeds its reimbursable network upgrade costs by roughly a factor of 5. The magnitude of these new transmission revenues for DEP is a benefit entirely sufficient to allay any concerns over ratepayer exposure to interconnection costs. In addition, in my direct testimony and rebuttal testimony, I explained the reasons why the Commission should issue a conditional Cpcn to Juno Solar. As background, the Federal Energy Regulatory Commission has approved revisions to Duke Energy's Attachment J, Standard Large Generator Interconnection Procedures, to their Joint Open Access Transmission Tariff. With FERC queue reform, Duke Energy has reformed their generator interconnection queuing, study process, and cost allocation process by transitioning to a definitive interconnection study process. Juno Solar has recently entered the transitional cluster, in which Juno Solar and other interconnection customers will be grouped together for the transition cluster study process and will be able to share any required network upgrade costs. There are substantial and increasing financial security requirements required for both ready and non-ready interconnection customers to enter the transitional cluster and proceed through the transitional cluster study process. The total security required for the transitional cluster study process, if readiness is provided, is as follows. 1 times the study deposit to enter phase 1 and $3 million to enter phase 2. The total security for the study process, if readiness is not provided, is as follows. 1 times the study deposit plus $3 million to enter phase 1, and an additional $2 million for a total of $5 million to enter phase 2. Therefore, ready projects will have to pay in excess of $3 million to enter phase 2 study, and non-ready projects will have to pay in excess of $5 million to be studied in phase 2. If an interconnection customer withdraws prior to phase 2 of the transition cluster study process commencing, no withdrawal penalty is imposed, and the interconnection customer will only be assigned its allocated study costs. However, after the commencement of phase 2, the interconnection customer runs the risk of having to pay a withdrawal penalty equal to 9 times its study costs, which is likely to be $1 to $2 million or potentially greater, in addition to losing the study costs already paid. Among the reasons that an interconnection customer might need to withdraw from the study process is if the Commission were to deny a Cpcn application. The Commission could decide to deny a Cpcn where it believes that the LCOT for any network upgrades are too high. This situation creates a catch-22 for FERC jurisdictional interconnection customers like Juno Solar that have to enter the transitional cluster and must make substantial financial posting and face substantial withdrawal penalties if they exit the study process because the Commission were to deny the Cpcn. But Juno Solar cannot determine the amount of its network upgrade costs and its LCOT without first completing the study process. The solution to this unfair situation is for the Commission to issue a conditional Cpcn that will remain in effect so long as the LCOT for any required network upgrades assigned to Juno Solar is at or below an acceptable defined amount. Juno Solar has conducted a detailed injection analysis of the project to identify anticipated transmission overloads and potential network upgrade costs. The study found that minimal network upgrades will be required, and Juno Solar believes that the LCOT for any required network upgrades assigned to the project will be no greater than $4 per megawatt hour. Finally, I explained in my direct and rebuttal testimony that the conditional Cpcn will ensure that the ratepayers are not subjected to unreasonably high network upgrade costs. Juno Solar has proposed a conditional Cpcn that will both provide protection to the ratepayers and allow Juno Solar to enter the transitional cluster and incur the associated financial exposure without an unacceptable level of uncertainty about whether the Cpcn will be issued and whether the issued Cpcn will remain in effect. Juno Solar has proposed the following conditions to the Cpcn to ensure that there will be no unreasonable harm or risk to the ratepayers. 1, the LCOT for any required network upgrades assigned to Juno Solar will be no greater than $4 per megawatt hour. 2, the conditional Cpcn will automatically terminate if the LCOT for any required network upgrades is greater than $4 per megawatt hour. 3, Juno Solar will agree not to seek reimbursement for any Duke Energy affected system upgrade costs that may be incurred. And 4, Juno Solar's Cpcn will automatically terminate if Juno Solar does not either contract for the sale of energy or the sale of the facility during the life of the Cpcn. This information concludes the summary of my testimony.
Thank you, Ms. Miller. I'll now move on to Juno Solar's second witness, which is Steve Levitas. Mr. Levitas, can you state your full name and business address for the record, please?
I'm Steve Levitas. My business address is 130 Roberts Street in Asheville.
By whom are you employed and in what capacity?
I work for Pinegate Renewables. I'm the Senior Vice President for Regulatory and Government Affairs.
And Mr. Levitas, did you cause to be pre-filed on November the 9th of 2021, 18 pages of rebuttal testimony in the form of question and answer and one exhibit?
I did.
And if I were to ask you the same questions that appear in your rebuttal testimony today, would your answers be the same?
They would.
At this time, I would move that Mr. Levitas's pre-filed rebuttal testimony be copied into the record as if given orally from the stand, and that the exhibit to his testimony be marked for identification and included in the record.
Any objection? The motion's allowed.
So Ms. Miller and Mr. Levitas are now available for cross-examination.
I do have a summary.
Oh, excuse me. Let me back up. Mr. Levitas, do you have a summary that you would like to read to the commission?
As a matter of fact, I do.
Okay, thank you.
Good morning, Commissioners. My name is Steve Levitas. I'm Senior Vice President for Regulatory and Government Affairs at Pinegate Renewables. I filed rebuttal testimony and exhibit in this docket on November 9th, 2021. The purpose of the summary of my testimony is first to explain the importance of finding a solution to the catch-22 problem for merchant plant projects seeking a certificate of public convenience and necessity, such as Juno Solar. Second, to provide information that the Commission should follow its precedent by applying the levelized cost of transmission, or LCOT test, to Juno Solar's conditional CPCN application to determine the reasonableness of the network upgrade costs. Third, to explain that the public staff is fundamentally changing its position in this proceeding about the appropriate test for determining the reasonableness of network upgrade costs. And fourth, to demonstrate that the proposed conditions to Juno Solar's CPCN application will provide ample protection for the North Carolina ratepayers from unreasonably high network upgrade costs, while at the same time not subjecting Juno Solar to huge financial penalties in the event of the denial of the CPCN application in the future. In my testimony, I first discussed the catch-22 problem for FERC's jurisdictional interconnection customers such as Juno Solar that wish to enter into the transitional cluster study process, but must make substantial financial postings and face substantial withdrawal penalties if they are required to exit the study process solely because the Commission denies a CPCN for the facility. I explained that I was extensively involved in Duke Energy Progress and Duke Energy Carolina's FERC jurisdictional queue reform stakeholder process as one of the primary spokespersons and drafters on behalf of Carolina's Clean Energy Business Association. I attended almost all of the stakeholder meetings. I was intimately involved in developing and negotiating solutions for issues that arose with respect to Duke's queue reform proposal, and I drafted detailed comments on and revisions to the various iterations of Duke's proposed modifications to the state and federal interconnection procedures. During multiple stakeholder conferences, these were mostly teleconferences, all of which I believe were attended by representatives of the public staff, I explained the catch-22 problem for FERC jurisdictional interconnection customers. I pointed out that a FERC jurisdictional interconnection customer that enters phase 2 of the transitional cluster study must make a substantial performance security payment and subject itself to a substantial withdrawal penalty well in excess of $1 million and perhaps more like $2 million if it exits the study process. Among the reasons that an interconnection customer might need to withdraw from the study process is if the Commission were to deny a CPCN application or revoke a CPCN. In the Frisian Holdings CPN proceeding, that was docket number EMP-116, the Commission made clear that it will, in some circumstances, deny a CPCN for a FERC jurisdictional interconnection customer where it believes that the LCOT for required network upgrades assigned to that interconnection customer, which under Duke's FERC approved OATT and large generator interconnection agreement are reimbursed in part by North Carolina retail customers, are deemed to be too high. However, the interconnection customer cannot know its network upgrade costs and thus its LCOT until it has been through the transitional cluster study and will not even have an estimate of those costs from Duke until the end of phase 1 of the study process. Thus, the catch-22 is as follows. Duke cannot provide the finalized network upgrade costs of a FERC jurisdictional project in the transitional cluster study until after completion of the phase 2 study. But if the Commission's CPCN decision for the project is not made until after those costs have been determined in phase 2 study and the remaining phases of the study process, and the Commission then denies the CPCN because it deems such costs to be unreasonable, the customer runs the risk of having to pay a withdrawal penalty equal to 9 times its study costs, which is likely to be, I believe I said in my testimony, 1 to 2 million. I think it's likely to exceed 2 million. That result would be unjust and would likely discourage FERC jurisdictional interconnection customers from participating in the transitional cluster study, thereby reducing the potential to spread the very large cost of resolving Duke's significant transmission system constraints and removing a major impediment to achieving the goals of House Bill 951. On several occasions during the stakeholder process, I explained the problem and then proposed 2 solutions. The first solution was to modify the interconnection procedures to allow a FERC jurisdictional interconnection customer to withdraw from the study process without penalty if the Commission were to deny its CPCN application based on the network upgrade costs assigned to the project. Duke made it very clear that it would not support this approach, understandably, because any such withdrawal might require restudy of the remaining projects in the cluster study, which would adversely affect those customers. My alternative proposed solution was the one presented in Juneau's CPCN application, that the commission issue a CPCN conditioned on its reimbursable network upgrade costs coming below a specific and reasonable LCOT value. No stakeholder, including the public staff, at any time raised any objection or concern about the conditional CPCN solution that I proposed. In my testimony, I explained that both the public staff and the commission have identified LCOT as the test for evaluating the reasonableness of reimbursable network upgrade costs for FERC jurisdictional interconnection customers. Specifically, in the Frisian order issued on June 11, 2020, the commission noted, I'm quoting, public staff witnesses Lawrence and Metz argued that a levelized cost of transmission analysis provides a tool to evaluate the reasonableness of the upgrade costs associated with certain generating technologies. They cited to a 2019 study by Lawrence Berkeley National Laboratory that reviewed interconnection cost studies for renewable energy facilities on a nationwide basis, doing so by calculating an LCOT value, end quote. The commission proceeded to state that, and I quote again, the commission views the LCOT analysis performed by the public staff as a benchmark of the reasonableness of the network upgrades relative to other similar transmission investments made to interconnect generating facilities in North Carolina, end quote. In addition, in the commission's November 13th, 2020 order granting a CPCN to the proposed Edgecombe Solar Merchant Plant, docket number EMP-116, the commission again used the LCOT metric to assess the reasonableness of upgrades required to the DEP system by the project. The commission concluded that an LCOT of $6 per megawatt hour for such upgrades, plus the cost of unreimbursed upgrades in PJM, was not unreasonably, quoting here, not unreasonably out of line with the 2019 Lawrence Berkeley National Laboratory interconnection cost study on which the commission has relied to place LCOT calculations in perspective with data from other balancing authorities, end quote. The commission further concluded that, quote, in view of the total cost of the facility, the siting of the applicant's facility in this area is not consistent with the commission's obligation under NC General Statute 62-110(1)D for the provisions of reliable, efficient, and economical service in the state. Commission also relied on an LCOT analysis to determine the reasonableness of upgrade costs in orders granting a merchant CPCN in docket number EMP-114 sub-0 and renewing merchant plant CPCN, a merchant plant CPCN in docket number EMP-92 sub-0. In none of these instances did the commission consider the cost of upgrades that might be associated with other proposed projects, except to note where upgrade costs might be shared with such projects. Furthermore, during several conversations I have had with the public staff, I have asked them directly what their test is for CPCN issuance to FERC jurisdictional projects, and they have repeatedly confirmed the position that they took in the Frisian proceeding, that reasonableness of network upgrade costs should be determined based on a comparison of the project's LCOT to industry benchmarks. Exhibit 1 to my testimony is an April 22nd, 2021 email from the public staff that states, quote, as we have discussed before and stated in testimony, we consider the LCOT a benchmark for reasonableness of network upgrade costs. In my testimony, I note that the public staff is attempting to fundamentally change its position and the commission's position in this proceeding. The public staff seeks to prevent the commission from determining a reasonable LCOT value for Juneau Solar by arguing for the first time that even if the LCOT for a FERC jurisdictional customer's reimbursable network upgrade costs are reasonable by industry standards, it might nevertheless be appropriate for the commission to deny a CPCN for the project. Specifically, the public staff is suggesting that it might be appropriate to deny such an application if either the total cost of the project's assigned network upgrades or the total cost of reimbursable network upgrades for all FERC jurisdictional projects in the transitional cluster are deemed to be unreasonably high by some undefined standard. The public staff's position is a complete reversal of the position it has repeatedly taken in the past. The public staff has repeatedly acknowledged that the commission may not, consistent with FERC's crediting policy, deny CPCNs to all FERC jurisdictional projects simply because any reimbursement of network upgrade costs by ratepayers would be required. Rather, the public staff has advocated that the commission must apply some rational and reasonable tests, such as LCOT, in making such decisions. The effect of the public staff's new position would be that the commission could arbitrarily deny CPCNs to large merchant plants relative to smaller projects, even if the required upgrade costs were reasonable by industry standards. Or the commission could impose an arbitrary limit on the number of permissible FERC jurisdictional projects because of their aggregate impact. In my opinion, neither outcome is constitutionally permissible. In my testimony, I emphasized that Juneau Solar has proposed reasonable conditions to the CPCN to ensure that the ratepayers will not have to provide reimbursement for unreasonably high network upgrade costs and any affected system costs. Juneau Solar's proposed condition will ensure that the LCOT for any assigned network upgrades from the study process will be no greater than $4 per megawatt hour. Thus, with a conditional CPCN, Juneau Solar will be able to enter the transitional cluster study process and incur the associated financial exposure without an unacceptable level of uncertainty about whether the issued CPCN will remain in effect, and the conditions to Juneau Solar's CPCN application will provide ample protection for ratepayers from unreasonable network upgrade and affected system costs being passed on to them. This is a reasonable solution that presents absolutely no risk to ratepayers. This concludes the summary of my testimony.
Thank you, Mr. Levitas. Ms. Miller and Mr. Levitas are now available for cross-examination.
Thank you. Good morning, Mr. Levitas, Ms. Miller. My name is Leila Cummings. I'm an attorney with the public staff. Today, Robert Josie and I, my colleague, both plan on asking you both questions. I'm mainly going to direct my questions at Mr. Levitas, though, and Mr. Josie will direct his questions to Ms. Miller. And I'm going to go ahead and start off knowing the time limits we have for Mr. Levitas with Mr. Levitas. Before we start, though, I think it might be easiest. We passed out a packet of cross exhibits everyone should have. If I can go ahead and mark those cross exhibits for identification. On top of the packet is attachment J to the Duke OAT. This is the standard large generator interconnection procedures. I would request that this be marked for identification as public staff Levitas cross exhibit number 1.
So marked.
Second one in the packet should be Duke's filing and FERC docket ER-21-1579 filed on April 1st, 2021. This is the interconnection queue reform filing at FERC. I would ask that this be marked as public staff Levitas cross exhibit number 2.
So marked.
The next document is the direct testimony of Kenneth J. Jennings, which is from the same FERC docket ER-21-1579, also filed on April 1st, 2021. I request this be marked as public staff Levitas cross exhibit number 3.
So marked.
The next document is the comments in support of Q reform filing, also filed in the same docket, FERC docket ER-21-1579, filed on April 19th, 2021. This is comments in support of Pine Gate Renewables. I would ask that this be marked as public staff Levitas cross exhibit number 4.
So marked.
Next document is motion for leave to answer and answer of the North Carolina Utilities Commission and the Edgecombe Solar Complaint docket, FERC docket number EL-2173, filed on June 30th, 2021. I request that this be marked public staff Levitas cross exhibit number 5.
So marked.
Should also have a presentation entitled Transitional Cluster Phase 1 Customer Engagement Meeting dated November 29th, 2021. We
Ms.
request,
Cummings, I do not have that document.
Extras. Sorry about that. Yes.
Ms. Cummings, do you have one for the back table?
We'll get some more printed. I think we are short.
Okay, thanks.
Apologize. We ask that that document be marked Public Staff Miller, cross exhibit number 6.
So Mark,
I also do not have that attachment. Oh, are you bringing it, Robert? Thank you. Thank you.
And last, you should have a copy of responses to public staff data request number 2, dated October 4th, 2021. We request that be marked as public staff Miller cross exhibit number 7.
Ms. Cummings, should we remark these as Public Staff Miller Cross Exhibit number 1, and then the second exhibit, Public Staff Miller Cross Exhibit number 2?
Yes, presiding commissioner, definitely that makes sense. Thank you.
Okay, so marked. Yes, clear for the record.
And just a note on that last one, public staff Miller cross exhibit number 2, there is a attachment that's marked confidential, but that confidentiality has been waived, so it's not confidential.
Okay, thank you.
All right, good morning, Mr. Levitas. How are you doing today?
Good. Good morning to you.
So I'm going to start with your rebuttal testimony, and you only filed rebuttal testimony, so to the extent I refer to your testimony, that's what I'm referring to.
Understood.
On page 3 of your testimony, beginning on lines 16 through 17, you state that Juneau is at risk of incurring enormous financial penalties in the event of the denial of a CPCN in the future.
Right.
And on page 4, lines 18 through 19 of your rebuttal testimony, you state that the withdrawal penalty will be in excess of $1 million if Juneau exits the study process after entering phase 2. Is that correct?
Correct.
If the project is studied in phase 1 and withdraws after receiving the final system impact study for phase 1, the phase 1 report, what are the withdrawal penalties, if any, under section 7 of the large generator interconnection procedures, which I've marked as public staff cross exhibit number 1?
Sorry, if the project withdraws after phase 1?
Before phase 2.
Yeah, there's not a penalty exactly. There's a requirement that the project pay its applicable study costs. The study deposit is $250,000. Presumably that represents a reasonable estimate by Duke of what those costs will be, although I believe that could be for the entire study process, so there may well be a refund after phase 1 if the project were to withdraw. The problem comes up after phase 1.
Mm-hmm. In the Duke FERC filing that is marked as public staff Levitas cross exhibit number 2, Duke states that as part of the TCS, they have provided a second customer engagement window at the end of phase 1, giving interconnection customers time to decide whether to make the more significant financial commitments to proceed through phase 2 of the transition cluster and to meet the increasing readiness milestones. Is that your understanding?
Yes.
And in the same filing, Duke states that the transition cluster study process was designed to incent any speculative projects to withdraw after phase 1, report before the utility undertakes more detailed and time-intensive phase 2 study process.
I'm going to take your word for that. I don't know where in the document.
I'm happy to point you to it.
I'll take your word for it.
And in the same FERC filing, the testimony of Ken Jennings, which is marked as public staff, Levitas cross exhibit number 3, Ken Jennings filed testimony on behalf of Duke. If you turn to page 23 of that testimony, In this section of the testimony, Mr. Jennings is describing the transitional cluster study process. And on lines 7 through 8, he states that interconnection customers withdrawing after phase 1 will only be required to pay actual study costs and will not be subject to penalties.
That's right. That's what I just confirmed.
And on lines 10 through 12, he says a customer withdrawing beyond the phase 2 customer engagement window will be obligated to pay withdrawal penalties. Then in the last paragraph, starting on page 16, he states that the downside of this approach is that it will likely result in restudy, but that was a compromise that resulted in overwhelming consensus with stakeholders and support for filings made with state commissions in North and South Carolina. Do you agree with that assessment?
Yes, I was a party to that consensus.
So starting on page 7 of your rebuttal testimony, you rebut witness Metz's assertion. So I'm on page 7. Line 19, beginning that question and going on to the next page, page 8. You rebut witness Metz's assertion that a conditional CPCN will not solve the problem you describe as catch-22. Specifically, you describe that Juneau will receive an initial estimate at the end of phase 1, at which time, if it is above the $4 LCOT condition, it will withdraw. You then state that the large generator interconnection procedures allows a project to withdraw if they go over 25% of the upgrade costs identified in phase 1.
Correct.
And here you are referring to section 4.7.1 of the large generator interconnection procedures, which provides that 25% exception to withdrawal penalties past phase 1 into phase 2.
Subject to check on the section number.
And I'm happy to point you to that in the exhibit 1 if you'd like.
Yeah. No, I'll take your word for it.
Okay. In Ken Jennings' testimony, he describes the additional circumstances a customer may withdraw without penalty. So this is page 43 of that cross exhibit 3 we were just looking at. He states,
Sorry, which page?
43?
Okay, I'm there.
He states that there are a number of circumstances where a withdrawal penalty would not be imposed. And that includes if the project elects to withdraw from the interconnection project and the withdrawal does not have a negative impact on other interconnection customers, and where the withdrawing interconnection customers' assigned system upgrade costs did not significantly increase between phases of the study.
Correct.
So returning to your rebuttal testimony in that section I was just on regarding the LCOT, you say, it's page 8, lines 11 through 15, you say if an increase of less than 25% in Juneau Solar's phase 1 allocated network upgrade costs would cause its LCOT to exceed $4 per megawatt hour, Juneau would likely withdraw from the queue at that point without penalty rather than risk the possibility that a subsequent increase in its network upgrade costs could cause the CPCN to terminate.
That's my testimony.
And so just to be clear on that point, if Juneau receives a phase 1 report in excess of $3.20, it'll likely withdraw.
I think there is a high likelihood of withdrawal in that circumstance because should there be an increase in excess, by the way, I didn't do the math, but I think your math's right. Should there be an increase that is less than 25%, Juneau would not be able to withdraw without penalty, but would be subject to revocation of its CPCN. Now there is that other off-ramp that you referenced relating to no impacts on other projects, but that is, in my opinion, very unlikely to come into play with Juneau given the interdependencies in southeastern North Carolina.
So you've mentioned it in your summary and in your testimony. You're familiar with the LB&L study that the public staff has referenced in the Friesian case and the commission has referenced in several EMP cases. And do you recall that in that study, the PGM average LCOT was $3.22?
That sounds right. I haven't looked at it in a while.
I can point you to that if you'd like. And the commission uses this study, or has in the past, as a benchmark of reasonableness, as you've also described.
Yes.
At this time, presiding Commissioner Duffley had asked that we take judicial notice of the Frisian order and the 2019 LBNL study referenced therein.
Any objection?
No objection.
Well, without objection, we'll take judicial notice. Thank you.
Mr. Levitas, if the commission or the public staff were in the future to look to a more up-to-date cost information study, something along the lines of the LBNL study, but with more recent data, do you believe, given the trends you have witnessed in PJM, that those costs would stay the same or go up or go down?
Well, I don't hold myself out as an expert on interconnection costs, but I do have a fair amount of exposure to that issue and read the trade press a lot. And it certainly appears that those costs are going up. So I don't know if that answers your question. But I will say, in response to your question, just to be clear about kind of my testimony and position, I have no objection to the idea that that the market benchmarks that I've referred to and that you and the commission have referred to may change over time. And so that's why we have kind of accepted the public staff's point of view that there shouldn't be written into rule a bright line standard that's universally applicable, and that the decision should be made on a case-by-case basis, but that they should be made on the best information that's available at the time.
Thank you. That does answer my question. Turning now to page 6 of your testimony. In a transitional cluster study, a withdrawing interconnection customer would be subject to a significant withdrawal penalty, you state, of 9 times the total study cost after phase 1. That's pursuant to section 7.2.6 of the LGIP, correct?
Correct.
Except as the off-ramps described earlier.
Right.
And down further on page 6, you state the possibility of this penalty will discourage projects from participating in transition or definitive interconnection system impact studies. For Juneau, if you elected to participate in the first definitive interconnection study, do you know what the withdrawal penalty is for withdrawing after phase 2?
I haven't checked that, but I'm pretty sure it is significantly lower than the transitional cluster study penalty.
The study deposit, or 3 times the actual allocated cost of the study project at phase 2 and 5 times at phase 3.
Yeah. I will say that there are significant public interest considerations in my judgment for moving this project through the transitional cluster study rather than waiting for DICES.
Turning now to the stakeholder process, you discuss beginning on page 7, on line 1, you state that during multiple stakeholder conferences, you described what you call a catch-22 and you proposed 2 solutions. In discovery, when asked for the dates of those meetings, you said those meetings were likely in February and March of 2021.
That's right. I don't have any contemporaneous records of those calls. I know one of them I took while driving down I-40. I do have a bit of email documentation that would help kind of frame those, and I'm sure Duke has a record of when those calls occurred and who participated.
These were meetings 15 and 16 of the Q Reform stakeholder group, and the 2 meetings held prior to the FERC filing, but after the North Carolina filing for Q Reform, and they were held on February 3rd and March 16th. Does that sound correct?
It sounds right.
And there's been a total of 17 Q Reform meetings.
That's right.
So this proposal was pretty far down the road in the Q Reform stakeholder process. Is that fair to say?
Which proposal?
Your 2 proposals to solve the catch-22.
Do you mean did I present them late in the process? No, I think I first identified them fairly early in the process. Certainly, well, while we were working on the state jurisdictional queue reform, it was the Duke's decision, understandable decision to work on the state proceedings before making a filing at FERC. It was sequential, but we were certainly contemplating the FERC procedures at the time that we were working on the state procedures, in large part because I think there was a recognition that solving this pressing problem of relieving transmission constraints on the Duke system was going to likely require a mix of state and FERC jurisdictional projects. So I, anyway, and I think others were thinking about how the two interconnected. I did go back and last night to try to see if I had any other email records beyond the one that's Exhibit 1. And I did find one set of email exchanges between myself and you and Mr. Dodge that dated back to November 23rd, 2020, and we appear to have had a conference call on December 4th, I believe. So I think these issues were on my mind as early as then.
And if your counsel doesn't mind, can we get a copy of those communications?
Sure.
You state in your testimony that the public staff did not at any stakeholder meeting express objection, but you raised your concern. Can you say whether any stakeholder echoed your concern?
I can't say for sure about that. I was the major spokesperson for the development community on many of these calls, and so I was typically speaking for a larger group than just myself. My recollection is that on the second call, I specifically addressed the public staff and with the intent of trying to confirm that there was not an objection or a problem from the public staff side with respect to what the problem that we were trying to solve.
And on that second call, do you recall if any public staff attorney was on the line?
I don't know. I'm pretty sure on all the calls there were public staff representation, but I couldn't say for sure.
Those two meetings, meeting 15 and 16, February 3rd and March 16th, the topic of those meetings was to discuss changes, draft changes to the LGIP and the LGIA. Was that correct to your recollection?
That's correct.
Did you add any of your concerns to the agenda for those meetings?
I don't know that I was given an opportunity to provide agenda items. I don't recall that I did that. I was having conversations throughout this time, as indicated by the email traffic, not only with the public staff, but with Duke, because I personally was very committed to trying to get queue reform approved. It was an extremely time-consuming, difficult, complicated process, and there was quite a lot of disagreement of opinion about the concept generally and the details of the proposals within the solar development community. I think it's fair to say that I was the most active participant in trying to work with Duke to achieve consensus and to make this important transition the way the queue is managed in Duke service territory. So towards that end, it was the highest priority thing that I was working on in that period of time, and I was talking to lots of people in trying to find common ground. And in particular, with respect to the FERC procedures, this problem that we're dealing with, this so-called catch-22, as I described, there were two possible solutions. One solution would have required that the FERC rules, the FERC procedures be changed. And Duke was actively seeking our support for what they were going to file at FERC. So what was on my mind at the time, what I communicated was, if we're going to support these changes at FERC, then we need to have a solution to this problem, because if it's going to be Plan A, which is a withdrawal right, that would need to be written into the FERC procedures. On the other hand, the conditional CPCN solution was within the control of the commission and wouldn't require any change to the procedures. So I was very concerned that we have an understanding about how we were going to solve this problem, because if the answer was we've got to change the FERC procedures, then I needed to know that before I put my name on a document supporting those procedures. And as I've testified, Duke, in my opinion, understandably did not think the no penalty withdrawal option was in the public interest or a good idea, which left us with the conditional CPCN solution.
When you proposed these two solutions, did you interpret the lack of objection from the public staff as approval?
I certainly had the expectation, particularly when I had indicated what I just said, that our support for these procedures was contingent on developing a solution. I had the expectation that if the public staff had a problem with what I was proposing, that you would let me know.
And did the public staff give any explicit or written feedback to your proposed solution?
I don't recall that occurring in the calls that we were just referring to. I do think that in some of the calls, and there were many, I feel like we did have some explicit conversations about the contingent CPCN. I think the sure if it's in Exhibit 1 or this other. In Exhibit 1 to my testimony, you'll see that began with an email to you and Mr. Josie of April 2021. And in the initial email that I wrote to you, I did explicitly refer to the conditional CPCN application. And I say, of the sort we have discussed, So it's an indication to me that as of April 21st, we had been talking about this idea, and I'm quite sure that you had not communicated an objection to me to the concept.
But do you assert that there was any communicated approval?
I can't make that assertion, no.
And for these stakeholder meetings, Duke solicited feedback in all its stakeholder meetings via an email inbox it set up and posted responses to those requests for feedback on its OASIS website. Did you submit a request along the lines of these proposals?
No, I'll have to plead technological incompetence. I had countless communications with Duke and other stakeholders about these procedures. I did not use that portal as a vehicle for those communications. There's all kinds of emails and other communications.
And other than in connection with this EMP application, have you made any filings before this commission or FERC detailing CCBA's position or Pine Gate's position that a conditional CPCN would be needed to accommodate projects entering a cluster city?
I don't believe so.
At the time the FERC filing was made by Duke in April of 2021, Pine Gate filed comments in support of Q reform. This is our Exhibit 4. Is that correct?
That's right. Duke was, I think, encouraging that other parties weigh in and support in the hope that we would be able to expedite approval at FERC.
Pine Gate supported Q reform even after the meetings in which the public staff did not respond to concerns you raised.
That's right. As I said, my assumption at the time was that the solution to the problem that I had identified was that we were going to be able to utilize a conditional CPCN procedure and not need to modify the FERC procedures. So we were comfortable supporting the procedures on that basis.
Okay, turning to a different topic. On page 5 of your testimony, you state that this commission will deny a CPCN based, quote unquote, solely on the fact that FERC's crediting policy requires the utility to reimburse the customer for network upgrade costs. Is that correct?
For network upgrade costs that are deemed to be unreasonably high by industry standards.
And that's a qualification you're making now, not in your testimony.
Can you point me to what you're
Sure.
referring to my testimony?
Page 5, line 14.
Yes, that appears to be sort of an abbreviation or shorthand for what follows later, because I think elsewhere and throughout my testimony, I make clear that what the commission has actually utilized is a reasonableness test based on LCOT. So it's not my intention to suggest that that the commission has denied or suggested it would deny a CPCN solely because there are reimbursable costs. And to the contrary, I've suggested I think it would be unlawful for them to do so.
Understood, but you, with your qualification earlier, you believe they would solely deny a CPCN such as Juno's based on the costs.
Based on LCOT.
I would like to turn to what I pre-marked as Public Staff Levitas Cross Exhibit number 5. That's the North Carolina Utilities Commission motion for leave and answer filed in the Edgecombe Solar Complaint FERC docket EL 21-73. Do you have a copy of that?
I do. I've not seen this before today.
Are you familiar with the Edgecombe complaint at FERC?
I'm aware of it, yes.
On page 4 of this exhibit, the commission states, and this is under the headline B, the third sentence, the NCUC has not adopted any rule, guidance, or practice that would require denial of a CPCN simply because the cost of network upgrades would be allocated in part to retail customers.
I'm sorry, where are you?
I'm on the third sentence under B.
I see that.
And further down,
And I don't disagree with that.
further down, when discussing the Frisian order, the commission says that it can consider all costs as, and this is the last sentence of that page, as one of the many factors to be weighed when determining whether generating resource is needed and is appropriately cited at the location proposed by the CPCN applicant.
Was there a question?
Do you think the commission has taken a different position than that in any docket?
Well, I note above that this filing says that the NCU's orders speak for themselves. And I do think the Frisian order speaks for itself. And I don't think that what's cited below is what the Frisian order says.
On pages 10 through 12 of your rebuttal testimony, you argue that the public staff is changing its position by suggesting the commission consider the total cost of network upgrades for one project or the total cost of network upgrades for the transitional cluster. Has the public staff before considered a CPCN application for an EMP, to your knowledge, that is participating in a transitional cluster study?
No, there hasn't been a transitional cluster study. I will say on that point, in terms of my testimony regarding the public staff's position, I have been persistent over a 2-year period in trying to ascertain the public staff's position as to the applicable test for merchant plant certification. And as evidenced in Exhibit 1 to my testimony, one of the more recent times where I put that question to you, the response, and I feel like you may have been getting a little bit understandably impatient with me because I kept asking the question so many times. What you said to me on April 22nd of this year is, as we have discussed before many times, that's my words, many times, stated in testimony, we consider the LCOT a benchmark for reasonableness. So yes, it is my testimony that if you're now asserting that there's a different test for reasonableness, that is a change in position and a departure from what you have communicated to me on multiple occasions.
On page 12 of your rebuttal testimony, you state that as a procedural matter, the public staff seems to have some vague concern about whether Juneau Solar can be held to the agreed upon conditions of the Cpcn, even though Juneau Solar has expressly proposed and agreed to them. Can I ask what the basis of this assertion is?
Yes, I think we responded to that in response to a data request. And I was reminded as we were responding to your data request that was communicated in a conversation that we had, I think in connection trying to understand the nature of the public staff's concern or opposition. And so it certainly does not appear in Mr. Metz's testimony. And if that issue is sort of irrelevant or inappropriate for consideration here, I don't need to pursue that, or I have to talk to my lawyers about striking it. But I didn't, at the time that we were preparing the testimony, I was conflating things that Mr. Metz had said with things that had been said elsewhere. That was said in a phone conversation.
I think it's, from our perspective, appropriate just to clarify that that's not based on anything in the record.
Fair enough.
On page 16 of your rebuttal testimony, can you read the first sentence starting on line 1?
Beginning Juneau Solar.
Yeah.
Juneau Solar was cited at its proposed location for the express purpose of seeking to help solve what is arguably the biggest impediment to large-scale solar development in the state, and in my opinion, the biggest obstacle to achieving the carbon reduction mandate of House Bill 951.
And just to explore that a little, Juneau was purposely cited in this area to resolve the congestion associated in the southeastern area of the state.
To help do so, yes.
Are you, in that assertion, speaking to the Frisian upgrades?
To the upgrades that were the subject of the Frisian proceeding, yes, that would serve many projects besides Frisian, yes.
But you're speaking to
The significant transmission constraints on Duke's system in southeastern North Carolina and northeastern South Carolina.
Okay. You go on page 16, lines 6 and 7, to say that Duke has confirmed the importance of these upgrades to its system planning. Can you explain how Duke has confirmed these upgrades are important to system planning?
I think we provided in response to your data requests, references to and perhaps copies of the Duke comments that were filed in the Frisian proceeding, where I think they made statements to that effect.
Are these upgrades, to your knowledge, needed for reliability purposes?
I'm not a reliability expert, and I believe there may be testimony suggesting that they're not needed in some sense for reliability purposes. My own view is that when not a single megawatt can be added to a significant portion of the grid serving 2 states, that there's probably a need to upgrade that portion of the grid for reliability purposes, but I'm not an expert on reliability.
On the same page, lines 18 through 20, you say Pine Gate and its development partners have actively sought to identify and develop projects like Juneau Solar that could participate in the cost sharing. Can you tell us what other projects are in the TCS owned or being developed by Pine Gate and its partners?
I would need for Ms. Miller to respond to that question.
At this point, I would just say that we have several projects in the transitional cluster across the DEP system. There are probably too many to name individually, but we could file an exhibit after the fact if helpful. And, not necessarily all of those are specifically for the express purpose of those costs. Some of them are just to help serve both, the needs we're expecting through House Bill 951 and a lot of the renewable energy mandates. And we feel that solar siting in the DEP system is easier and less complicated than the DEC system, where it is much more challenging to site projects of that size.
And if I could add, Ms. Cummings, I've been on something of a mission for the last several years to try to solve what I believe is one of the most significant problems facing our state today, which are these transmission constraints in the southeast part of the state. Because I believe, as someone who's worked for a long time in the solar industry, that we cannot achieve the governor's goals of decarbonization without getting these upgrades built. Frisian Solar came before this commission with one possible solution to that several years ago, which was to allow a federal project to go forward. There would be reimbursement of the upgrades. Other projects would benefit. That proposal was rejected. Understood. Once that occurred, I then said, well, now what do we do? And I said that to members of the public staff. And the solution to how we solve this problem was to move forward with a cluster study process with Q reform, which is a large reason why I devoted so much of my time for over a year to Q reform, so we could get Q reform procedures in place, get a cluster study process in place, get as many megawatts into that cluster study as possible to spread those costs, some combination of state and federal projects, so we could finally break this logjam and move the state forward. And we talked about that many times. And the public staff specifically said to me, I asked the question, this is what I'm going to go do now. Plan A didn't work. Do you agree that that's the right approach to solving this problem? And I was repeatedly told, yes, that's what we think should happen. Let's have a large cluster, spread the megawatts as much as we can. And it was understood there would be, unlike the Frisian case, where a federal project was going to get reimbursed for all those costs, in Plan B, there would be a mix of state and federal projects that would participate in funding those upgrades. Yes, the federal projects would be subject to the crediting policy, but there would be a lot of state megawatts in there that would significantly reduce the impact to ratepayers resulting from the crediting policy. So that's what I've been trying to make happen for a couple of years. And having this project participate in the transitional cluster study, in my belief, is essential to that strategy having a chance of working.
It is possible, though, that this log jam created in this particular area could be solved in subsequent clusters.
It is theoretically possible, but there's several problems with that. One is time. So we're going to lose a year in coming up with a solution. And that means costs are likely going to go up. Achieving the goals of 951 are going to be impaired. But we also don't know how that may complicate things. And I think, I think in the Frisian proceeding, Duke's comments indicated that if we could just get this problem solved, everything becomes so much easier. And not wait a year or 2 years to solve it, but find a way to get it solved now. And that's what I've been trying to make happen.
Turning to page 17 of your testimony, lines 10 through 11, you're speaking to the Frisian case, which of course you participated in. You say that the public staff did not argue, let alone put on any supporting evidence that the network upgrades at issue were unneeded or inefficient. Is that correct?
I did say that.
And you're, of course, familiar with Mr. Metz, who's a witness today, and Mr. Lawrence joint testimony in that proceeding?
I am. I haven't gone back and looked at that lately, so I probably was going on memory for that.
Presiding Commissioner Duffley, I would ask at this time that we take judicial notice of Lawrence Metz joint testimony in docket EMP 105.
Without objection, that is allowed.
Thank you. On page 14 of your testimony, you say, under the CPCN that Juno seeks, if its calculated LCOT ever exceeds $4 a megawatt hour at any time before the execution of an interconnection agreement, the CPCN would automatically terminate.
Right.
How frequently will Juno update the commission on its LCOT calculation?
I'm glad you're asking that question. We've been talking about that a lot and want to be sure we're very clear about that. And Ms. Miller may want to add to this, but we think it would be appropriate for there to be a condition on the CPCN that requires Juno to provide updated information in real time immediately upon receipt of any updated information, both with respect to the total interconnection costs and the LCOT calculation using the public staff's methodology, which you provided to us, so that occurs in real time, and that would result in the CPCN automatically terminating. I would just also note, and I think it's in Ms. Miller's rebuttal testimony, when we made the initial filing, we proposed the idea of not quite so automatic a termination, and that perhaps we could come into the commission and say, well, it was just a little bit over $4. Maybe you should give us a break and reconsider. And we've withdrawn that request. So we're now proposing the $4 dollars per megawatt hour as a right line test with no avenue for relief.
Thank you for that clarification. The CPCN, if it automatically terminates, does it do that by its own terms, or will that require an order from the commission, in your view?
Well, I would leave that to the commission. There might be some value in having that in the record for interested parties to know that that CPCN had terminated, but it would be ministerial. We make the filing. There's no debate about whether it should happen. It just would happen.
And has Juno determined that if the LCOT goes over $4, whether it would, even say if the CPCN terminates, just as you described, would it continue in the transitional cluster study process?
Again, Ms. Miller may have some thoughts about that. I don't think so. I think if the CPCN is not issued or terminates, it's going to be very difficult for this project to go forward because of the uncertainty about its certification status. And, I think at that point, Miller talked about the 951 compliance. I think it becomes a lot more likely, maybe somewhat likely today, but it becomes a lot more likely that this project becomes a Duke acquired project under 951.
And Duke, obviously they'll file a carbon plan, and this commission will determine, will approve that plan after stakeholder input. But in your opinion, or how you might represent Pine Gate or CCVA going forward, do your organizations think there will be competitive solicitations in the nature of CPRE going forward for PPAs and asset acquisition type, how this facility might fall under a utility owned?
Yes, I can tell you what I think as somebody who spent a lot of time working on House Bill 951. First of all, there will have to be different procurement, maybe somewhat similar, but different procurement because of the different ownership structure created by 951. PPAs will no longer be competing with utility-owned projects, so there'll be silos or separate procurement of those two types of assets. The bill does not speak in the same way that House Bill 589 did with respect to competitive procedures, but it does have a least cost requirement, which leads me to believe that it's likely that there will be competitive procurement. Again, EPAs being procured in one bucket and utility-owned assets being procured in another. None of that, of course, has been established or defined yet. And I don't think there's anything in the legislation that prevents Duke from going out tomorrow and saying, we need to get to work and buying a project like Juno.
One thing that may be preventing Duke from doing that is there's not a carbon plan yet developed.
That's true. I'll leave it to Duke to decide how they interpret the bill. But I mean, the one thing I will say is it's just hard to overstate the time urgency if this goal is to be achieved, because there has to be an enormous amount of procurement that occurs in a very tight time frame to have any chance of achieving the governor's goals and the legislature's goals.
And these silos, as you envision it, Juno could probably only compete in a solicitation for the utility owned.
That's right. There's an 80 megawatt cap for PPA projects. There is no such cap for utility owned projects.
That's
Which is good for, that's good for ratepayers because larger projects will almost certainly be able to be delivered at lower cost.
Turn it over now to my colleague, Robert Josie. Questions for Ms. Miller? Thank you.
Thank you very much. Good morning, Ms. Miller. How are you?
Good morning. Good.
I am going to try to keep my questions kind of in subject matter groups. So I may jump back and forth between your revised direct testimony, your supplemental testimony, and your rebuttal testimony. So if you have any questions on which one I'm referring to, just let me know.
Okay.
So on page 23 of your revised direct testimony, you mentioned that Pine Gate performed a power flow analysis. Is that correct?
Yes, that is correct.
And in your supplemental testimony, page 2, you discussed that the projects modeled in the power flow study, you modeled different projects in the power flow study. Is that correct?
Correct.
Okay. Were there 2 power flow analysis done, or was it just one?
Just one.
Just one. And when was that power flow analysis done?
I believe it was conducted right around the time when we first mentioned it. And I can't recall if it was first mentioned in the direct testimony or the supplemental testimony.
But in July.
Correct.
Or
Yes, it
before
was
July.
pre-close of the transition cluster.
Pre-closed, yes.
So
Thank
before
you.
October.
So before October 31st, and yes, and obviously before today, which is the last day that projects can drop out of the transition cluster before the power flow study begins, correct?
That's correct.
Okay, thank you. And you state in your testimony that the power flow analysis that resulted in a $13 million upgrade if it were, on a conservative basis, and a $16.84 million upgrade scenario on page 6 of your testimony. Is that correct?
That's correct.
Yeah. And but Duke must complete its own study in order to come up with the final analysis of what the upgrades will be.
That is correct.
And those results will be what is used to determine the cost of Juno's final upgrades, correct?
Yes.
Thank you. I'm going to switch over to discussing, I think Mr. Levitt said a little bit on this, but I just want to kind of follow up on some milestone payments and withdrawal penalties. On page 9 of your revised direct testimony, you state that the estimated construction cost of the facility is approximately $370,690,000. Is that correct?
That is correct.
And we heard from Mr. Levitt earlier that the study deposit for Juno was $250,000.
That's right, around $250,000.
And so the LGIA section 7.2.6 states that the penalty is 9 times the interconnection request total study cost imposed.
That's correct. So it would be around 2.25 million for Juno if the full study cost were allocated.
And subject to check my math, 2.25 million would be approximately 0.6% of the total projected construction cost of the Juno facility, correct?
That is correct. You may be getting at this point, but there, from a development perspective, we do see the development expenditures for an earlier stage facility to be at risk and a question of risk exposure when there are still potential binary risks outstanding for the project that could ultimately kill the project or stop it from proceeding. So that 2.25 million could be $2.25 million absolutely lost for the facility, as opposed to the construction cost for the facility, which ultimately at that point, we would likely have a financial counterparty lined up, have obtained a construction loan for those costs, and at that point have obtained all necessary permits and approvals to build and operate the facility. So we would consider that all risk to be, eliminated or fully de-risked at that point. So we do view a difference of at-risk exposures in the early stage of the development process versus the construction funds, which are procured through a construction lender.
Understood. And is it your understanding that the purpose of the transition cluster was to remove speculative projects from the queue in order for the cluster study to move forward in an expeditious manner?
It's my understanding that the transition cluster was intended for projects that had already been in queue for a while and were serious projects that intended to move forward.
You state on page 5 of your rebuttal testimony that you believe the uncertainty of whether the commission will grant a CPCN to a merchant facility might dissuade FERC jurisdictional interconnection customers from entering phase 2 of the study process due to the magnitude of the withdrawal penalties.
Correct.
And I would like to refer you to Miller Cross Exhibit 1, which I believe is entitled the Transition Cluster Phase 1 Customer Engagement Meeting. Do you have that in front of you?
I do. Yes.
I would like you to turn to page 7, 8, and 9, slides 7, 8, and 9, please. And particularly slide 9. This is the list of DEP transitional cluster projects. And I believe you can look through and correct me if I'm wrong, but all the FERC jurisdictional projects are within the transitional cluster are listed on page 3, slide 9 of the Pew report.
Most of them, correct. It appears so.
Yes. And subject to check, there appear to be 8 FERC jurisdictional queued projects in the transition cluster.
Correct. I believe there may be one more further. There is one additional FERC project that's actually a battery on page 6, but otherwise that appears to be correct. So
Yes, thank you. And of those 8 on page 3, 5 of them are in North Carolina.
Correct. It appears so.
And 2 are solar projects.
I believe there, 2 in North Carolina.
2 in
correct.
North Carolina are solar projects.
That's correct.
And the first one is a 275 megawatt project in Richmond County.
Correct.
And
That
that
is
would be-
Juno Solar.
That would be Juno. And the other one is a 69.9 megawatt project in Scotland County.
Correct. That is Frisian
And
Solar.
that is Frisian. So those are the only 2 North Carolina FERC jurisdictional solar projects in the transition cluster.
Correct.
And Pine Gate has a development interest in both.
Correct. We are responsible for the development of both facilities.
And Frisian has already had a denied CPCN.
Correct. I believe it is currently going through the appeal process, but looking to Steve Levitas to confirm.
I'm sorry. what's the
If
question?
needed.
Yeah.
I don't think we need you
Yeah,
right
I
now,
think-
but just in case.
And on page 23 of your testimony, you say that the solution to the patently unfair and unreasonable situation is for the commission to issue conditional CPCNs.
Correct. We believe so.
Yes, and that patently unfair and unreasonable situation you're referring to is that Juno can't find out its system upgrade cost until it completes the study process.
It's the problem statement is the significant financial exposure that a FERC jurisdictional project like Juno would be subject to proceed in the transitional cluster process without knowing its interconnection system costs until quite far into that process, once significant financial payments are made.
Have projects in the past or other jurisdictions ever completed the study process without a CPCN?
I'm not sure I can speak to that accurately, but typically you do obtain a CPCN early on in the study process from my experience.
But it is possible to complete the CPCN or the study process without a CPCN.
I think it is possible, but the question of whether that is considered good business practice based on the risk exposure is a different question.
And you're aware that the study process, along with the milestone payments and the withdrawal penalties, were developed through a lengthy stakeholder process, as we've discussed here today,
Correct.
and that the NCIP changes reflect those changes to the study process and were approved by this commission.
Correct.
Yes, and like the commission to take judicial notice of its order in E100 sub 101, the Q reform approval order on October 15th, 2020.
Without objection, the commission will take judicial notice.
And judicial notice that, and you are aware that FERC also approved this process as well.
Correct.
In the okay, and I'd like to take judicial notice of FERC's order accepting tariff revisions in ER 21-15 79-00 and ER 21-1579-001 issued on August 6th, 2021.
Without objection, the commission will take judicial notice.
I would like to point out on that point that I believe it was in Steve Levitas's rebuttal testimony that we did acknowledge this situation and potential issue for FERC jurisdictional projects during that process. And it was our understanding after discussions with the public staff that a conditional CPCN could be one way based on LCOT to solve that problem. So I believe in some ways there was reliance on prior discussions that would be solved.
And on page 3 of your rebuttal testimony, you state that a conditional CPCN would not eliminate all risk associated with the interconnection. The commission's issuance of a conditional CPCN to Juno would appropriately mitigate the substantial financial risk that Juno would face if it has to withdraw from the transitional cluster study, correct?
Correct.
And so is it your contention that the commission must weigh the financial risk of applicants when determining whether to grant a CPCN?
I think it's our hope that the commission and the public staff will seek to find what we would all consider a reasonable solution to an unintended problem.
And on page 5 of your rebuttal testimony, you state that the conditional CPCN with a $4 LCOT is designed to provide ample protection of ratepayers from unreasonably high network upgrade cost, correct?
Correct.
Is it your contention that anything over $4 is unreasonable in this situation?
I don't believe that we've contemplated that or that we're taking a position necessarily on what would be unreasonable beyond that threshold. But $4 is what we believe is a reasonable threshold for Juno Solar specifically.
Okay. Would an LCOT over $4 be unreasonable in any situation?
I think it's up to the commission and the public staff to view it on a case-by-case basis and determine what is justified for an individual merchant facility, since each facility, of course, is unique.
Madam Presiding Chair, at this time, I would like to ask some questions that may touch on confidential information.
Okay, we need to clear the courtroom of anyone that has not signed a confidentiality agreement. And John, we're going to need to stop broadcasting. Yes. webcast. Mr. Josie, do you have further questions?
No further questions at this time.
Okay, redirect.
Yes, I have a couple of questions for Mr. Levitas on redirect. And Mr. Levitas, I'll begin with a line of questioning that Ms. Cummings had asked you about the stakeholder process, and you're having raised the catch-22 problem and potential solutions. And I believe that Ms. Cummings stated that that you raised this catch-22 problem late in the stakeholder process. It consisted of approximately 17 meetings. Do you recall your testimony about that?
I do.
And can you describe for the commission the focus of the stakeholder process, whether it was primarily focused, the length of time primarily focused on the state jurisdictional Q reform stakeholder process or the FERC jurisdictional Q reform process?
The vast majority of meetings were devoted to the state process.
And the vast majority of time and number of meetings?
Yes.
And then you were also asked by Ms. Cummings about whether the public staff provided any specific feedback to your solution to the catch-22 problem during the stakeholder process. Do you recall that exchange?
Yes.
Okay. And I think that your response is during the stakeholder process that you did not, the public staff did not provide any actual feedback. Is that correct?
That's correct.
Okay. After the stakeholder process, can you describe to the commission the conversations and information that was provided to the public staff about the conditional Cpcn application before it was filed?
Well, to be honest, I don't recall all of that sequence of events. I don't know if you have a document that would refresh my recollection. I did mention that the email that, and again, I'm not remembering which was the exhibit and which was the one that I discovered. I guess the exhibit to my testimony was some record that right in that same time frame, I was seeking to confirm with public staff their position as to how this would work so that it would be successful.
And subject to check, we filed the conditional Cpcn application on July the 12th of 2021. Does that sound accurate?
It does.
And do you recall whether we had any virtual meetings with the public staff shortly before filing the conditional Cpcn application?
I'm certainly aware that we were seeking to give the public staff a heads up of what we were planning, and you may refresh my recollection, but I've had so many conversations and Zoom calls with the public staff on these topics that they run together a little bit.
And subject to check, would you agree that we provided a copy of the conditional Cpcn application to the attorneys for the public staff before we filed it?
We did.
And do you recall whether we asked for feedback from the public staff about the conditional Cpcn application?
I'm sure that's why we provided it to them.
And do you recall whether we received any feedback from the public staff?
Don't recall receiving any feedback.
And then, Mr. Levitas, you were also asked by Ms. Cummings about whether it would be possible or preferable for Juneau Solar to participate in DICES as opposed to the transitional cluster study. And you provided some information about some benefits, some public benefits that would be provided to the state based upon solving constraints in southeastern North Carolina by participating in the transitional cluster study. Are there any other benefits to the state or to the ratepayers for Juneau participating in the transitional cluster study as opposed to DICES?
Well, I am very concerned that if Juneau does not participate in the cluster study or is required to withdraw after phase one because it doesn't have certainty around the CPCN, that the transitional cluster study will implode. At a minimum, if it has to withdraw, there will almost certainly have to be restudy. But my main concern, as I think I said during Cross, is that it's vitally important to spread the upgrade costs in this critical region of the state over as many megawatts as possible in order for any project to be able to absorb them. So if Juneau is able to pick up a portion of those costs, it means that other state jurisdictional projects will have a lower share of the costs and potentially be viable and able to get these costs done. And the biggest concern that I have for the ratepayers and the public interest is that if these upgrades are not made feasible as a result of the transitional cluster study, well, first of all, I have no idea what's going to happen in DICES, but there's a very good chance that they won't get resolved in DICES either. And then we're really in a mess. And I also would just point out that in the transitional cluster, there are quite a number of state jurisdictional projects, including ones controlled by our company, that will bear their share of those upgrade costs. One of the objections in the Frisian proceeding, a major objection, was that there were going to be state projects that effectively would be free riders because the FERC jurisdictional project would be reimbursed for all the costs. That was one of the benefits and beauties of the transitional cluster study, is that those state projects would not get a free ride. They would have to bear their costs. Admittedly, there would be some FERC jurisdictional projects that would get reimbursement, but that was certainly a big improvement over the situation that was presented by Frisian. And I would argue it's a big improvement over what would be likely to happen if the transitional cluster study doesn't work. Because my belief is that the transitional cluster study is not successful, that these upgrades will eventually get done and they will be 100% paid for by North Carolina ratepayers. So there's an opportunity here, if the transitional cluster can be successful, to spread some of those costs to state jurisdictional projects, including ones that we control, and we're quite prepared to pay our share of those costs.
And finally, Mr. Levitas, you just testified that if the transitional cluster is not successful and the qualifying facilities do not pay their fair share and pay 100% of the network upgrade costs that are assigned to them, that the ratepayers will likely end up paying for the cost of the network upgrades. Can you explain, especially in light of House Bill 951, how that might work or what the concern is?
Well, I think we were talking earlier about competitive procurement under 951. Those rules have, of course, not been established, but my expectation is that, as with House Bill 589, that where projects are competitively procured, that it is in the ratepayer interest to for any upgrade costs to be paid by ratepayers rather than be embedded in PPA bid prices. But also keep in mind that 55% of all solar projects that will be procured under House Bill 951 will be owned by the utility, and by definition, their upgrades will be paid for by ratepayers.
Thank you, Mr. Levitas. That's all the questions I have.
Okay, commission questions?
I just have a couple. Mr. Levitas, during one of your exchanges with Ms. Cummings, I believe you were discussing the value of not establishing firm rules across the board for all projects, but looking at projects on a case-by-case basis and with the best available information, I think was the phrase you may have used. You recall that exchange?
Do.
Let me ask you this question. Would we not be in a better position to know what the estimates are on transmission upgrade costs at the end of the phase one cluster study? We would know what Duke's estimate was, phase one estimate, understanding that that's subject to phase two study, but we would also know their initial estimate of what would be allocated to the Juneau project, what would be allocated to other projects, and how many other projects might be bearing the cost, wouldn't we?
Well, you would, but if
that's information we don't have today.
That's right. I guess I would say two things in response. One is procedurally, it would appear to be very difficult to get projects through the Cpcn process between the end of phase one and the time that firm financial commitments have to be made and withdrawal penalties become applicable in phase two. It's a very narrow window. But perhaps more substantively, your question, Commissioner Clodfelter, implies that those total costs or absolute costs are relevant to the decision about the CPCN. And as we've indicated in our testimony, we believe that LCOT is a reasonable test. It's the test that this commission has approved. And let's say that you get this information and there are $100 million of total FERC jurisdictional costs. I don't know how many FERC jurisdictional projects are in the transitional cluster. I know there's some, but let's say you have an absolute, phase one yields an absolute value on those costs. It's my position, our position, that is not relevant information, not permissible information to consider in denying a siting decision for an individual project. That you're going to deny that siting decision because there are 3 or 4 projects over here that have some impact on ratepayers or on the costs. And so we think you've got it. Well, as you know, the Frisian case is on appeal. We have some disagreement about that. But if there is going to be a test, if there is not complete preemption of siting authority, we believe that LCOT is the correct test, that the public staff has stated that the commission has relied on it. And as long as you have, and if that's so, as long as you have a condition linked to LCOT, that information, you don't really need to make the decision. Now, you might want to decide if you don't think $4 is the right number, that's obviously your prerogative to say that's not the right number. But once we get the phase one information, it will either be below whatever number you decide is reasonable in this case or not. And that will decide whether this CPCN remains in effect or dissolves.
Thank you for that answer. Let me ask you a couple of follow-ups. I mean, right now, the only application for CPCN I have before me is this one. So what would be the procedural problem with simply holding the record open on the decision of this CPCN and simply taking into the record the phase one cost estimate for allocation of this project?
I'm going to go out on a limb because I haven't thought about this before, but I want to be responsive to your question. If what you mean is that that you would create a procedure in this docket to issue a CPCN based on a LCOT number, but you just want to wait until you have that information from phase one, and then there would essentially be an immediate issuance. In other words, sort of a condition precedent, so that you had made the decision. And
Don't put too many ideas into my head, Mr. Levitas. Let me simplify the question for you again. I'm just going back to the idea that more information is better than less information. And today I have no information. I have a proposal that we put a condition in order, but as to what the actual LCOT for this project will be, I have no information right now. So all I'm simply asking you is what would be wrong with my getting at least one additional bit of information, and that is the phase one estimate, before I make a decision on this petition?
Well, is that going to determine whether you think $4 is the right number?
It would give me an LCOT number on phase one, at which I could look at and say, is that too much or is that not enough? Or is that fine? What's the harm in doing that?
Well, to my earlier point, if the CPCN decision can be finalized, well, 2 things. If the CPCN can be finalized before the phase 2 commitment has to be made, that would go a long way towards solving the problem. I will say that the posture that we're in right now is not irrelevant, in that we've got to spend $250,000 on study costs. And we also have other costs that are associated. We've already incurred costs of $500,000 or so on this project. And we have to do those going forward without any, in the absence of a conditional CPCN, any guidance, any benchmark, any way of knowing whether we're ultimately going to be able to move this project forward. So we are at a disadvantage. And I guess what I'm missing is understanding why how your decision about whether $4 is a reasonable number would be affected as to whether, if you come back and the number comes back at 350, or it comes back at 250, how does that change your decision? as to
Suppose
whether-
it comes back at $25. Would I not want to know that?
Well, that would kill the CPCN under the condition that we proposed.
It would, again, I'm not asking about your proposed conditioning. I'm
Yeah.
asking about the information that would be useful to me in deciding whether the costs of this project
Right.
are too great at this location to warrant issuing a CPCN. Wouldn't it be beneficial to me to have more information rather than less information?
Well, I don't mean to be difficult. I'm just not sure why. You know, if I make a decision that I'm willing to pay $20,000 for a car and I go in the market, I don't necessarily need to know that whether the car costs 15 or 30, I'm only going to pay 20. So
You seem to be shifting your ground a little bit from where you were with Ms. Cummings. You seem to be suggesting to me now that I just fix the price in advance and simply apply it across the board going forward. If I'll pay $20,000 for that car, I'll pay $20,000 for the next car.
no, let me clarify on that. First of all, I think we may have said this in some testimony. We've accepted the notion that while there may decisions may be informed by prior decisions, we're not asserting that any of this is binding precedential decision-making. And the second thing is, with respect to my point to Ms. Cummings about updated information and the like, the main thing that I want to communicate about that is that LCOT is a test based on market conditions, market benchmarks. And we understand, I acknowledge with Ms. Cummings, those may change over time. And so, but the time frame that we're talking about here is a short time frame. But I understand that you would not want to publish a rule that says LCOT of $4 is okay, and then we find out 2 years from now that the average market LCOT is $1.50. So we're in agreement on that. But I guess what I would hope to see is some general guidance to market participants so they have an idea about what the rules of the road are.
Thank you. That's helpful. Let me ask you one other thing. If I had the phase one estimate and I knew who had been studied in phase one, and I knew the total cost that had been allocated to those projects studied in phase one, and I knew how much was allocated to your project, then I would have two numbers, would I not? I would know what the number would be allocated in phase one to your project, and then I would know what the maximum number your project might have been assigned if everyone else had dropped out of phase one. I could see the upper bound in phase one too, couldn't I? And I might look at that, and say, you know, even at that number, I think it's warranted. I'd have that information too, wouldn't I?
Yeah, yes, I think that would be helpful information. I think that the problem that we face is how do we get to phase two with certainty about our certification so that we don't face a $2.25 million withdrawal penalty because you decide to withdraw or revoke the CPCN at some future time.
I hear you. I understand. Thank you. I have one more question. I have some questions from Ms. Miller, but I'm going to stop with my questions with Mr. Levitas because of the time, and then
Right.
I have other questions later from Ms. Miller. This is a question purely out of curiosity. So last year, in the report from the North Carolina Transmission Planning Collaborative, they reported a special case study on transmission projects that might be required in Cabarrus and Union counties under certain conditions. Has Pine Gate or Juneau or anyone else you're not ever asked the Transmission Planning Collaborative to conduct a special policy case study on southeastern North Carolina?
Not to my knowledge, but I'm not associated with our transmission planning group. I will say that I was a little surprised, learned in the course of the Frisian litigation that, as I understand it, that transmission planning group really focuses on replacement needs to accommodate age and wear and tear of the system and is not particularly focused on planning to accommodate new growth. And
Actually, the Cabarrus and Union study was premised on precisely that. The policy case studies are not simply on replacements or reliability. They're on actually looking ahead under different scenarios of what might be required to bring offshore wind into North Carolina, or in this case, what would happen if growth projections in Cabarrus and Union exceeded current estimates.
Good. Well, I'm glad to know that.
I just was curious if anyone in your group has ever considered drawing upon that resource.
Well, I think we should. I'm not, perhaps we have. I'm just not aware of it.
I'm just thinking about the policy problem you've presented today and thinking about avenues for how to address
Thank you.
it. Thank you. That's all I have for you.
Just a few. Mr. Levitas, talk some about the constitutionality concern that you have. Just help me understand sort of the legal issue there.
Well, first I'll tell you my belief. My belief is, leaving aside the preemption issue that's on appeal, that I thought it was generally recognized, certainly by the public staff, had these conversations with public staff, that this commission, any state commission, cannot say permissibly, constitutionally, that we simply don't like the federal policy and we're going to refuse to acknowledge it, and we're going to deny a permit for any project that would benefit from it. And that instead, and what I believe you undertook to do in Frisian, was to say, what we can do is, as part of our citing authority, and to, I think Commissioner Cloudfilter used some of these words, can make a decision about whether we think a particular project is appropriately cited in light of the cost that it would impose on the system and the ratepayers. So anything that to me amounts to an absolute ban on FERC jurisdictional projects in the state of North Carolina because of a blanket objection to the crediting policy, I think is really problematic.
Okay, is that's the constitutional concern of which you speak in regards to the public staff's position on ELCOT?
Yes.
Okay. Okay, just a few more for you. Can you help me understand the transitional cluster? How is it going to work? My understanding is fairly limited, pursuant to that which y'all have which the parties have put in front of us, but it's going to be open for a finite period of time and projects can apply. You've testified today that you're concerned that the transitional cluster could implode. So I need to understand that testimony, and I also want to understand how the transitional cluster is actually going to work in practice.
Sure. So the window has closed. And there's a defined universe of projects that are now in the transitional cluster study. The actual phase 1 study will begin
December 1st, I
December
believe.
1st. The actual study is going to begin, leading to the phase 1 power flow results. At that point, the costs that are identified will be allocated to the participants in the cluster study. And they will be advised of their share based on the allocation methodology and the procedures that you approved. And those customers will then elect either to proceed to phase 2 or to withdraw. They proceed to phase 2, they then become subject to various withdrawal penalties. I have been in regular conversations with Duke throughout the year about the pipeline. And Duke has done a good bit of work to try to analyze the pipeline, including conversations that I've had since the window closed, all with the goal of trying to determine, do we have a transitional cluster study that will work? Does it look like there are enough megawatts in here that the cost could be spread so have a reasonable LCOT for the FERC jurisdictional projects? And so the state jurisdictional projects, which will have to bear their own costs, are getting an allocation that is financially viable. Because if the amount comes back too high for a state project and that project is no longer financeable, it's going to fall out. And so tried very hard to confirm that we were on a track for having this thing work. But We've all invested a lot in it, and it's really important that it be successful. And at least all the indications that I've gotten is, looks like it could work. We don't know who will drop out when they get their number. Somebody could, their pro rata share could come back at $1 million on a 10 megawatt project, a state jurisdictional project, and the developer could say, can't handle it, I'm gone. And so what happens is the projects drop out, you reallocate the pie. And of course, the risk is that as projects drop out and other projects get a larger share, that then they in turn won't be able to bear those costs. They drop out too. That's what I refer to as the implosion, the downward spiral. But the indications that I've had is that if we can keep all of the megawatts that are currently signed up for transitional cluster in the cluster, we have a reasonable chance of getting this thing to work, and that the pro rata allocation to all of these projects will be reasonable, both from the standpoint of what state jurisdictional projects can bear on their own, and within the LCOT kind of parameters of what you all at least have seemed to find acceptable in the past. So I've got my fingers crossed, because it's really important to the state that we make this work.
All right, thank you for that explanation. So help me understand, just keeping in mind that I'm not an engineer. So help me understand how the projects that have the universe of projects, interconnection requests that we now have in the transitional cluster process. How is there any assurance of sort of geographic proximity on the grid? I mean, how do we know that there are going to be projects that actually are clustered that should rightfully or appropriately share in costs?
Well, all that is done as part of the power flow study. All of that is looked at.
But in terms of who applied to participate in the transitional cluster.
Right. So Duke will take the universe of all those projects. They will run power flow analysis, assuming all of those projects are coming onto the system and will be onto the system. And they will do interdependency studies. And an important thing to keep in mind is that there's not a single upgrade that's required. There's many upgrades that are required as part of to resolve these constraints. And so some projects may contribute to 2 of those. Some projects may contribute to 6 of those. And Duke has a formula that was, again, part of the procedures for how those get allocated among those various projects. But when the dust settles, at the end of phase 1, Duke will give a number to each one of those projects and say, here is your pro rata upgrade cost for which you will be responsible if you stay in this transitional cluster. Are you in? And if you raise your hand and say you're in, then you then within a 30 days or some defined period of time have to put up your money to cover the cost of those upgrades.
Okay. And so do we have, what can you tell me about what projects, what is this universe of projects that have elected to participate in the transitional cluster, or that are at least have been studied by Duke?
My understanding is that it's on the order of 1,500 megawatts in the, I'm honestly, I'm not sure if that's the full transitional cluster or the ones that are potentially interdependent on the southeast upgrades, but it's a significant number. And Duke has continued to, as I said, to express optimism to me that this could all work. But my sense is it's precarious, and if any significant number of megawatts drop out, there's a real chance that it won't work. One of the other things that I just said in this context is that if we were to decide with Juno to go ahead and go forward with phase 1, even in the absence of a Cpcn, and then we come back with a number that's $3, and we're concerned, well, we still don't know what the commission's going to do. That's a little too close for comfort. We better drop out. Then there's a real good chance that that's going to throw the whole cluster into, at least into restudy and possibly into non-viability.
Okay, and just so I'm clear, what happens? Follow that through to its logical conclusion, and then what?
Well, so if projects start dropping out because they have too high a share based on phase one, you'll iterate down and see if anybody's left. And if everybody drops out, then nothing happens in transitional cluster. All those projects will now be out of the queue. They will have to reapply to the queue for DICES in the spring. And now we will be back with some new universe of projects back in the same boat with another year of study ahead of us to figure out whether we can make this work the next time around. And, I don't know of any reason to be more optimistic at that stage. I sort of feel like this is the best chance we've got, and we need to take it. We need to be sure we don't lose it. And as I said, I'm particularly concerned about any delays as it relates to 951 because the timeline is so crucial that we get on with the business of adding new non-carbon resources in order to achieve the goals.
Okay, thank you for that additional explanation. You've talked about,
Chair Mitchell, can I interrupt just to detail on one question you asked?
sure.
Of the megawatts that you identified for Chair Mitchell, what proportion of those require CPCNs in South Carolina?
Well, South Carolina only requires CPCNs above 75 megawatts, and I'm not aware that there are a bunch of those.
In that group?
Yeah.
Thanks for letting me.
You've testified about the criticality of southeastern North Carolina as relates to, meeting the requirements of 951. Help me understand why. I mean, why are you so certain in your testimony that southeastern North Carolina is critical and solar development in southeastern North Carolina is critical to meeting 951? I mean, solar development is occurring all over the state. There is significant amount occurring in the northeastern portion of the state. It seems to me that solar developers have had success in developing all over the state. Why is this one particular area that has significant transmission congestion critical?
Well, I'm going to ask Ms. Miller to supplement what I say, but what I'll tell you is this. It's a very large area, first of all. It's 13, 15 counties. It is absolutely the best land for doing solar. And once you get into the Piedmont and certainly beyond, there are huge challenges that are faced in siting solar facilities. Topography, contiguous land availability, population centers, which lead to potential for local opposition or just other issues that have to be addressed. I can tell you that it's been since CPRE was adopted, where the heavy focus of procurement was in Duke. All the solar developers have been trying to find sites in DEC's territory because that's where CPRE is focused. It is extremely difficult. There are people who really know this business who have been scouring the landscape for years, and what they have come up with is limited and is nowhere near this volume of capacity that is needed to achieve the goals of 951. And I think Ms. Miller touched on it. The other thing that we really need to be thinking about is the least cost mandate of 951. And in the solar business, least cost means bigger. And it's just basic economy of scale. And the only way that we're going to be able to drive the cost of 951 compliance down for ratepayers is if we build bigger sites. And those can pretty much only be built in the East. You want to add anything?
Yeah, no, I think you covered it very well. I would just also note that most of the facilities that we do see in DEC, as Steve mentioned, are quite a bit smaller. And even within what is participating in the transitional cluster, they tend to be closer to like the 30 to 40, 50 megawatt range. And I would say 50 megawatts, sometime even on the higher end. Whereas in DEP, you tend to see projects that are able to be quite a bit more sizable and more cost effective from just a land perspective. There tends to be flatter land, better solar irradiance. So we have higher yield, better production in that portion of the state. And also, solar facilities, of course, it's very dependent on proximity to infrastructure as well. And we tend to find better parcels of open land with close proximity to the transmission infrastructure needed in the DEP system than we do in the DEC system.
Thank you for that. All right, Mr. Levitas, a couple more for you. Let's see. As I understand, Juneau's position in this docket, it would agree to, or it has proposed a conditional CPCN with the $4 sort of being that, the threshold, above which the CPCN would terminate or become void. And this is something that Juneau has proposed, and presumably would agree to. Are you aware, or are you aware of the American Beach proceeding at the FERC?
I'm aware that it's pending. I'm not aware of the details.
So you're not aware of sort of you're not aware of the nature of the issue before the FERC in America?
Not with any confidence. You might refresh my recollection.
That's okay. I'll just move on.
Yeah.
All right. Let's see. I think I understand your testimony about sort of the transitional cluster, how it works, with respect to sort of at least your testimony about the necessity of the 275 megawatts kind of propping up development. But you talk about the state jurisdictional projects in the pipeline, or in that universe, in the transitional cluster universe, that would absorb their share of, or their allocation of, upgrade costs. Help me understand the nature of those state jurisdictional projects. Are they QFs?
There's certainly a number of QFs, including ones that we're involved with.
And you don't have, to me, just generally, I don't expect you to know specifically. Yeah.
In the transitional cluster, I guess there are some potential GSA projects in transitional cluster.
Yeah, they would have several offtake options, but generally there are, I would say, primarily QFs.
Okay, and you're getting at my question, which is who's gonna, what would be the power sale arrangements for these state jurisdictional projects?
Well, they would either be QFs with 5-year PPAs or GSA projects with 20-year PPAs.
Okay.
I guess I should also say that it is possible that a transitional cluster study project could potentially participate in some future competitive solicitation as well.
Okay.
It would not be in the CPRE Tranche 3, because that is going to be studied through a separate resource solicitation cluster. But it's possible that you could have a project come through transitional cluster study and just be ahead of the game in terms of whatever procurement may occur in 2022.
Okay, thank you, Mr. Levitas. I have nothing further.
Okay, looking at the time, we're just going to move forward with Mr. Levitas and come back to Ms. Miller. So with respect to this defined universe of projects, do all the participants know who is in this universe, or only Duke?
I don't know whether that information has been made public or is accessible by other parties or not.
There's no information about the owners of the projects, so it should be primarily known by Duke. But presumably, with research, people could put 2 and 2 together about the owners.
Okay, and would there be any objection from the parties for the commission to obtain that defined universe of projects from Duke? without sharing with the parties, obviously.
We have no objection, so long as Duke is willing to provide it, but we have no objection.
Public staff has no objection. We will point the commission to public staff Miller Cross Exhibit 1, which does have the transition queue projects as of yesterday.
Okay, thank you.
And we do have the list with the names. It's confidential, but we do have that information.
Okay, thank you for that information.
And if I might, Mr. Duffley, I had not seen this exhibit, and it's dated yesterday. So it's possible that there is more current information than what I had when I was responding to Chair Mitchell's questions in terms of the status of the transitional cluster. It looks like there's a lot of information here.
Okay, thank you. And Juneau is within this, is this the phase 1 list of the, so Juneau is part of phase 1 at this point?
Yes, I believe that these.
Mr. Levitas.
Sorry.
I'm happy to answer.
Yep, Ms. Miller, if you can answer.
Yes, Juneau is part of the phase 1 study, and this should be comprehensive of phase 1, although I will note that projects, I believe, had up until November 30th until today to elect to withdraw without penalty. So it's possible that some projects have changed since yesterday.
Okay, and when the study results, as I understand in my review, maybe the study results for phase 1 will be issued on March 31st, 2022. And how long do the participants have to elect to move into phase 2? Is it the full 30 days, or do they have to elect at some time prior to that 30-day period?
My assumption is that you are given 30 days, but there is, Duke has encouraged participants to make an election and post a deposit as quickly as possible so that they are not, working up until the nth hour trying to put everything together. So there will likely be motivation and pressure to move forward as quickly as possible within the 30 days.
Okay, thank you. And then, Mr. Levitas, going to your constitutional concerns, as I understand the public staff's concern in looking at all of the projects versus one project is the fact that the process has changed from a first to cause to this type of cluster study process. And I just want to throw out a hypothetical to you and then ask you the question. So let's assume many projects are built, state and federal projects, and there's an increase in wholesale rates of 70%. And as you know, that increase will trickle down to retail rates. And public staff is charged with protecting consumers for affordable rates and not to have overbuild of the system. So I've heard you say that the levelized cost of transmission should be the metric to use, but do you have another suggestion for the commission? Are there any other metrics or any other types of review that the commission can do holistically so that the rates do not rise to an unaffordable level?
I don't have a thought about that off the top of my head. I guess the concern that I expressed is, maybe to reiterate, is the commission has opined in the Frisian case, supported public staff, that in terms of the federalism, the balance of allocation of authority between federal and state, that the commission retains citing authority with respect to particular projects. And so my thought about that has been that requires a decision to deny Cpcn to be based on information about characteristics of that project. And that it would not be permissible to say, we've just got too many of these federal projects in our state and we're closing our borders and not allowing any more in.
Okay, thank you. And so this is to both of you. In Mr. Metz's testimony, he discusses need. And obviously, there's we don't have any cost yet. So his interpretation of need is not based upon any type of upgrade cost. So, and the public staff found that the applicant has not made a sufficient showing of need for the facility. And I just wanted to hear what your response is to this determination by the public staff.
Yeah, I think we would disagree. I think we feel there is a significant need for the facility shown by the demand in PJM for solar resources, especially of this size and type that would likely be very cost effective. And of course, we've got the preliminary term sheet executed with a large commercial buyer that indicates their strong interest in the full output of the facility. And in addition, with the enactment of House Bill 951, as we've mentioned previously, there will be a strong need for substantial additions of solar. And Juneau is not only a solar facility, but also a solar plus storage facility. So it has the capability to provide flexible generation as well, which is an added benefit amongst other ancillary services. And due to its size and other factors, it is likely the most cost-effective facility to contribute to those goals at this point in time, or one of the most cost-effective facilities. So we see that as several strong avenues for need for the facility.
Okay, thank you. And we may come back to that, but I want to get through staff questions. My fellow commissioners asked most of my questions. So if Juneau ultimately ends up selling its output to a commercial customer within PJM, the PJM region, there'll be some wheeling that needs to occur, and it's staff's understanding that there would be additional studies regarding how to wheel it, and that would add potentially to additional transmission upgrades. Has Juneau initiated those studies?
Correct. So Juneau would need to work with DEP to conduct a transmission study, which would function very similar to an interconnection study in some ways. We have had preliminary discussions with DEP about that. We intend to initiate a transmission study in the near future. DEP does publish their current available transmission capacity online. And based on what they've published today and in the past, we believe that there should be more than sufficient transmission service available for the Juneau facility. But correct, we would conduct that study to be aware of any requirements there.
Okay, and if there were upgrades that would be needed, would that be part of the levelized cost of transmission?
I don't believe we've discussed that previously, but we have committed to the $4 LCOT cap being inclusive of any system upgrades required in any affected system studies in Duke. So I believe that would be inclusive of those as well.
Okay, thank you. And the next question is, let's assume that the ultimate buyer ends up being DEP. Would it then turn the interconnection agreement, would it become state jurisdictional rather than FERC jurisdictional?
I was under the impression, which may be incorrect because I haven't dealt with the siting and permitting of Duke-owned facilities, but I was under the impression that their facilities were FERC jurisdictional by nature, but maybe I'm wrong about that.
Okay.
Commissioner Duffley, while I'm speaking, having not previously seen this Exhibit 7, can I just point out a couple of things to you that seem of interest to my earlier testimony?
You may.
I'm looking at page, it's a two-sided exhibit, so I guess I'm looking at page 5. And this is information about what's in the transitional cluster, which you were asking about. And I would just point out a couple of things. First of all, you'll see that the solar projects in DEC and DEP, consistent with what you've heard from Ms. Miller and me, that there's about 4 times as many projects in DEP as DEC, which is consistent with what we've said about the difficulty in siting projects on the DEC side. In addition, if you look at the DEP breakdown, you'll see that there are roughly 1,300 megawatts of state jurisdictional projects and 735 megawatts of FERC jurisdictional projects. So about 2 to 1 state to federal. So that tells me 2 things. One is that if things proceed and these FERC jurisdictional projects are able to participate, you will potentially have reimbursement under the crediting policy, but you're getting 2/3 of the cost of these upgrades potentially paid for by parties other than North Carolina ratepayers, which seems very attractive to me. I also would say, just looking at these numbers, where you've got an aggregate in DEP of around 2 gigawatts, I think that is consistent with my suggestion that there's not a lot of margin for error to have a large project drop out, accounting for 10% or more of the total, without running a risk that the other projects start spiraling downward. I just wanted to make those observations. I appreciate you letting me do that.
You're welcome. And my last staff question's for Ms. Miller, so I'm going to hold that question. Questions on commission questions?
May I also observe, Mr. Levitas, that too, that it answers one of my questions, which is there are 2 very large FERC jurisdictional projects in South Carolina in the transitional queue that aggregate about 14% of the total. Both of them connect to the Florence Kingstree line. So thank you for getting me the answer to my earlier question.
I do have a few questions for witness Levitas based on Chair Mitchell's questions regarding, transition queue and the purpose of transition queue, and maybe perhaps it would implode if we don't go forward with a conditional CPCN. Your assertion seems to be that the purpose of the transition queue is to resolve the congestion in southeastern North Carolina, but isn't it true that the purpose of the transition queue, as it's been described in, FERC filings, is really that the current serial study process has resulted in numerous delays because we have a lot of high number queued projects that are non-viable and speculative and are holding up the queue so that these lower numbered viable projects can't be studied. They can't move forward. And this is really a transition mechanism. You have to pick serial or you have to pick transition cluster. You have an option right now. And this process, this first transition, the purpose of it really is to clear the queue so that you can proceed with transitional cluster studies. And if transition queue does not result in, what you're hoping it will result in, which is building the upgrades to resolve this congestion, there is another opportunity in DICES to do so. In fact, it's probably likely more projects will proceed in DICES where the withdrawal penalties are lower. Is that a reasonable assumption?
Well, you covered a lot of ground there. Let me respond first by saying I would certainly agree that the primary purpose, the reason for queue reform and for the transitional cluster, was to clear the queue, the backlog, move to a more workable, more viable system of interconnection study. And you'll notice from your exhibit that I believe, I just looked at it quickly, I think 13,500 megawatts of projects that were in the queue have dropped out rather than moving forward in the transition process. So it is accomplishing its purpose. That said, recognizing that that process was underway and that we simultaneously have this problem that has related to transmission constraints, every problem, related to transmission constraints that many of us, including Duke, believe need to be solved. And these are the conversations that we had some time ago. It was perceived, determined, concluded that the best available solution to that problem was to try to create a transition cluster that was sufficient to spread these costs in a way that would be acceptable so that these upgrades could go forward. Your last question to me was about, well, doesn't DICES do that just as well? And I think there are a couple of problems with that. One is timing. If we don't get this problem solved now, we will lose a year, and we can't afford to lose a year. I say we, the people of the state of North Carolina, whose interests have been established by the legislature in creating an urgency towards decarbonization. We can't afford to lose that year. We will also increase costs. And I think there's no question that delaying this further will further increase the costs. It also, I would submit to you, I said that these state jurisdictional projects, 2/3 of what's in the transitional cluster now, may not come into DICES as state jurisdictional projects bearing their own costs. So you may be looking at a situation with DICES where all of those costs are going to be borne by ratepayers, because everything that is in that future procurement is going to be procured pursuant to 951.
And just to follow up on 951, if we proceed as you envision with 2 silos of competitive procurement and a CPRE-like process, we'll have an approved carbon plan by the end of next year. We'll start DICES January 1st, 2023, and we'll probably have a lot of projects coming in, right?
Well, for the DICES study is going to start in the middle of 2022, I believe. I mean, if what you're saying is that there are going to somehow be a lot more projects, one of the things that is a consideration here, and I think Duke spoke to this in their comments in the Frisian proceeding, is that it would be a whole lot easier from a study standpoint to take these 65 projects that are there now, get them studied, get them processed and moving through to interconnection agreements, and then deal with whatever's coming in, than starting over, losing all the benefit of transition cluster, starting over and having a DICES cluster that consists of 200 projects. That is going to be a massive undertaking for Duke to study. And so I think getting this study done now, getting us on a path to getting whatever upgrades are called for done now, greatly facilitates not only 951 implementation, but the successful implementation of DICES going forward.
That's not my question.
Ms. Cameron.
Mr. Levitas, I want to follow up on 2 lines of questioning. The first questions came from both Commissioner Clodfelter and Commissioner Duffley, and it relates to, I think, one of the initial questions that Commissioner Clodfelter asked about. I think he said, wouldn't it be better to wait to issue the CPCN until after the phase 1 results are provided? And your response, part of your response was about the narrow window of 30 days between phase 1 and having to pay security for phase 2. And can you provide any information about whether you think it's feasible or problematic to be able to obtain a CPCN within a very short 30-day period?
Well, I don't have all of the timelines in my head of the Commission's CPCN rules. But just off the top of my head, I don't see how it is possible. And also keeping in mind that there's some lag time, maybe Ms. Miller could speak to it, between the time that we would get a decision and all the things that we'd have to be doing to secure financing and making arrangements to participate in phase 2, because we will have to make significant posting. So it just seems like an extraordinarily tight time frame, and I'm just not sure from the Commission standpoint how they make that decision. You know, is there going to be further proceedings? Is there going to be opportunity for hearing? It seems incredibly compressed.
Ms. Miller, were you wanting to add something about the financing aspect?
Yes, just for some further color, like you mentioned, it would be probably $2 million at a minimum and $5 million at a maximum that we would need to prepare to post within that 30-day period. And given the size of that deposit, we would need to be engaged with our, financing parties, development lender, well in advance of that date and teeing them up to pay that. So I do agree that it's a very compressed timeline.
And Mr. Levitas, my last question, I'll go ahead and ask you to expedite this, to look under tab 7 of the notebook that I had prepared, and on page 9, and this is the public staff's response to Juno Solar's data request number 1.
Okay.
And this is following up, my question follows up the questions that came from Commissioner Duffley about whether you had any thoughts about whether there is another test that might be reasonable to assess the reasonable of network upgrade costs. And do you recall that we provided to the public staff question number 20, in which we tried to obtain information about whether any other state commission has utilized a test in addition to or other than LCOT? Do you recall that question?
I certainly see that question.
Okay. And can you describe to the commission what we learned from the public staff's response?
You want me to read the response?
Please do.
No, the public staff is not aware of any other tests used by other state commissions. We also have not done any search or survey of other state commission approaches. The commission authority to grant or deny specific to state law, GS 62-110.
Okay. And is that consistent with your understanding of law in other jurisdictions as well?
Well, I too have not done a survey, but I'm not aware of any other jurisdiction that uses a different test.
Thank you. That's all the questions that I had.
Okay, thank you. Any other questions for Mr. Levitas before we allow him to be excused? Seeing none, you're excused. Safe
Thank you very,
travels.
very much for accommodating my schedule. I really appreciate it.
You're welcome. Okay, now we'll turn to commission questions for Ms. Miller.
Just of time, I think I'll not pursue the question.
All right, Ms. Miller, just one or two for you. You testified today about the CNI demand in PJM for renewable energy. Talk a little bit about what you mean by demand for renewable energy. I mean, the transactions being entered into between a solar generator and a CNI customer that's located somewhere within the PJM footprint. It's not a power sale arrangement, is it?
It could be a physical power sale arrangement or a virtual power sale arrangement. In either case, it represents a physical need for power of renewable source. Even if not being directly delivered by the facility itself, they would just procure that energy on the open market where they're located.
Okay. But the customer would still be taking power from whatever load serving entity serves it. Is that correct?
That is correct.
Okay. And so when you say there's demand for this type of product, it's sort of what do you mean? Help me understand what you mean by demand.
Sure. So we're seeing a lot of large commercial industrial customers increasingly create their own carbon reduction goals or renewable goals in the pursuit of their own, environmental and sustainability goals. So that is driving a lot of increased interest in contracting directly with renewable facilities and especially solar plus storage facilities.
Okay. So a solar generator that enters into a contract, as you've described with the CNI customer, would that solar generator also participate as a seller in the PJM energy market?
They,
Generator, I'm sorry.
correct, they would.
Okay. And what about would the generator be able to participate in the capacity market?
They could if, so for specifically for a facility like Juno Solar that is wheeling power to PJM, there is kind of a two-part wheel required to participate in the PJM capacity market. So we would not only need to procure firm point-to-point from DEP to the PJM interface, but also firm point-to-point transmission on the PJM side of the system. So there is an opportunity for a facility to participate in the capacity market. PJM.
Okay. Okay, I have nothing further. Thank you.
So when was the Juno project first initiated? I don't mean the CPCN, but when was it first envisioned?
So Juno Solar was formed, I believe, in October of 2020 and entered the queue at the end of the year in 2020.
Thank you. So you mentioned that the Juno project's one of the most cost-effective options for Duke to achieve its compliance with House Bill 951, but you're in negotiations with a PJM off-taker. So how do you square that statement, I guess?
Correct. I think with any facility, we always look for offtake optionality and where there are different cases of need. So with Juno, we currently intend to pursue, initiating a transmission study, continuing discussions with that PJM offtaker, but a lot of that will largely depend, of course, on the interconnection study results as well, since a lot of those power contracts carry very significant financial security. So we don't anticipate signing a contract in the very near future for the contract for the sale of energy from the facility, I should say. We would explore concurrently a potential sale via House Bill 951 with Duke as an option, and in likelihood would initiate those discussions or participate in any procurements that occurred in 2022, if not already contracted.
Have you already started those negotiations with Duke?
We have had very preliminary discussions with Duke at this point.
Thank you. In your direct testimony on page 15, you mentioned Level 10 Energy, which provides insight into renewable PPA pricing. And you state that it notes that PPA prices in PJM are increasing because, and there's a list. Number one is more challenging local and state permitting regimes. Which states and localities is that referring to?
So PJM primarily has a lot of supply from Virginia, Pennsylvania, and those states have generally less land availability and produce smaller size solar facilities and have more of an uphill battle as it pertains to zoning and permitting, which often cuts off supply from projects that could otherwise move forward.
And are there any other issues?
And as it relates to permitting, I think that's the primary concern, is that it's challenging to find projects of a significant size that carry cost efficiencies and economies of scale, and difficult to get projects approved as well to be able to meet that demand.
Then the second point was it mentions prohibitively high grid upgrades, and then I guess report goes on to say that the PJM market is short on solar project supply. What's the time frame when solar projects will be built within the PJM footprint, or is that really not an option?
So PJM projects are studied in a cluster process, just like Duke is initiating. So there are kind of waves of projects that are able to proceed through that process and be built. I think the issues that persist in PJM are not expected to diminish. There is also a active stakeholder proceeding occurring with a key reform of its own, if you will, for PJM's interconnection process that has expected to backlog projects really throughout this decade, for new projects being able to come online if they are not already in receipt of an interconnection agreement.
And so, but in your opinion, do you see utility scale solar as viable in the PJM footprint?
There's certainly utility scale solar, I think, being developed in the PJM footprint. But the question is there enough of it to meet the demand that is continuing to increase, whereas supply is continuing to be constrained?
Okay, thank you for that. And then the one staff question, I don't understand this, but they do. How will the facility be designed to ensure that the storage component does not take power from the grid? If it does take power from the grid, the interconnection study would need to be conducted twice, once in the facility as a generator and once as a facility as a customer. What's your response to that?
So the solar component of the facility is a closed loop system, meaning it's a DC coupled system. So it is designed only to charge from the facility itself and not to charge from the grid. And it's our understanding that Duke does not allow storage as it currently stands connected to a facility to charge directly from the grid.
And actually, I do understand that. You had a further question?
I had a line of questioning that I wasn't going to pursue, and then you sort of got into it, so I kind of have to ask. It's a quasi-rhetorical question, so you don't have to answer if you don't want to. But if you have a comment in response to it, you can, and I'd be interested in your comment. So I'm hearing that it's really critical that we resolve the problem of transmission constraints in southeastern North Carolina, which includes Richmond County, because it's going to be critical to our ability, absolutely essential to our ability to meet the goals of House Bill 951, that we be able to aggressively develop solar projects in southeastern North Carolina. They're the best locations. So here I have one of my best locations to meet my state policy goals, and it's going to be selling into the PJM market. What am I supposed to do with that fact when making a decision about public convenience and necessity?
Well, I think the facility still has a strong opportunity to be sold to Duke. So I would say that, as we've mentioned throughout the hearing today, that is still absolutely an option for the facility.
I understand you, and I take you at your word, and I don't doubt you for 1 minute. I'm really, as I say, quasi-rhetorically suggesting that the problem of optionality is not just in this case, we're seeing it constantly. And optionality presents us with a difficult situation. Suppose we were to find in one case that there is no showing of need, but there is a showing of need in the other case, and for the other option. How should I deal with that in making a decision about whether to issue a CPCN when the optionality is still open and not yet closed? Don't answer that. I don't expect you to answer that. It's simply a policy issue that we have to grapple with.
Sure. Yeah, it's a complicated question. I will share that the thing that makes Juno Solar unique from other solar assets located in Dominion territory in North Carolina is the benefit of the wheeling revenues that Juno will be paying to Duke's transmission system. And as we've mentioned, that revenue, in all likelihood, all of the dollar figures we've quoted are, I would say, quite conservative, because we are likely to also reserve non-firm transmission on top of whatever firm transmission we reserve. But are substantial, and a substantial benefit to Duke's system and to the transmission grid. And of course, there's also the likelihood that if the facility has some sort of contracting arrangement in PJM, because it's physically located in the Duke system, the firm transmission service is a minimum of 1 year and a maximum of 5 years. So there is optionality within that bit to, to design the length of the contract and the length of the firm transmission to have the ability to serve the Duke system more directly in the future.
Thank you. I wasn't going to even start down the road, but
Commission, questions on commission questions?
Just a few. First of all, you mentioned the battery that'll go along with the Juneau facility. Has the battery entered any kind of study process?
The battery is included in the interconnection queue position with Juneau because it is DC coupled. They can be studied as a single facility.
And you talk about when Chair Mitchell mentioned the C&I demand for renewable energy in PJM territory. Where is the majority of that demand within the PJM territory?
I don't know that I could speak to that directly, but I think the demand is across PJM more broadly, but I would say Virginia and Pennsylvania, which of course are extremely close to North Carolina, is where a lot of the demand is occurring.
Thank you. You spoke earlier about the timelines for the Wheeling transmission study, or you spoke of a Wheeling transmission study. Do you know what the timeline for that study?
Yeah, so as we understand it, so we've spoken with Duke about this, their transmission team. The study itself is in some way tied to the interconnection process. So in any event, we expect that the transmission study will be complete prior to the end of the actual interconnection study process, but it will have some connection to that.
And then my last question is just as we talk about wheeling power from this facility into PJM territory, do you know if that will have any effect on the current affected systems issues that we are seeing in the northeastern part of the state?
I believe we've looked at, again, I don't want to speak out of turn, but I believe we've looked at this and we don't believe that it's going to impact that specific issue. But of all the potential affected systems that Juneau could trigger, because it is, importing power into PJM, it is most likely that it would be identified that there is potential PJM affected systems. And actually, I'd like to point to, I believe in one of our data requests, we had addressed this based on our injection analysis. And I'm happy to point it out in a minute. All to say, I believe we concluded somewhere in our data responses that although we expect, okay. I'll just read it if that's okay.
Yeah, if you could identify which request.
Sure, so this is data request number 2. Data request number 2, question number 12A. And it says, please provide documentation that ensures that this project is not triggering any affected system utility studies. And our response was, through the course of Birch Creek's injection study, all tie lines to neighboring utilities were monitored for potential overloads, and none were found due to Juneau's power flowing into adjacent systems other than PJM. It should be further noted that these potential violations delivering power into PJM are triggered by 3 natural gas projects amounting to over 4 gigawatts within a 5-bus radius of an area tie line between DEP and Dominion Virginia powering PJM, with Juneau minimally contributing to and not causing the potential violations.
Okay, thank you very much. And just to make the commission aware that data request response she is referring to is within Public Staff Miller Cross Exhibit number 2.
And briefly, Ms. Miller, in response, Commissioner Clodfelter had asked you a question about the public convenience if Juneau Solar is selling into PJM. and you provided some information about the uniqueness of this project selling into PJM due to the transmission payments to DEP. Is that right? Are there, assuming that Juno Solar does sell into PJM, if it facilitates the upgrades in southeastern North Carolina, will there be any benefits to the state and to the ratepayers for compliance with House Bill 951?
Absolutely. So as we've mentioned several times throughout the course of the day, we believe that the Juneau facility is critical as a critical component of unlocking the log jam, as we say, in the southeastern portion of the state, where we believe much of the new solar generation could come online in the most cost-effective way to meet the goals outlined in House Bill 951.
And my last question, Ms. Miller, is in response to a question from Mr. Josie about affected system upgrades. Can you tell the commission about the condition that Juneau Solar is willing to agree to in regard to affected system costs?
Absolutely. So in our, I think it might have been my rebuttal testimony. In my rebuttal testimony, we agreed that the $4 LCOT cap would be inclusive of any system upgrades and any affected system studies that would impact North Carolina ratepayers. So that would be inclusive in that $4 LCOT request.
And following up on that, Ms. Miller, was there another condition related to an agreement by Juneau Solar about seeking reimbursement for affected system costs?
We agreed not to seek reimbursement for any affected system costs that would impact North Carolina ratepayers.
Okay. Thank you. That's all the questions that I have.
Okay, thank you. I believe that ends your case in chief.
Yes, it does. Thank you.
I'll take a motion from public staff regarding the cross exhibits.
Yeah, I move our cross exhibit. I move to have our cross exhibits 1 through 5. Public staff, Levitas, cross exhibits 1 through 5, and public staff, Miller, cross exhibits 1 and 2, moved into the record.
Any objection?
No objection.
Without objection, so moved. So we have come to, thank you very much. You may step down.
Thank you very much.
So it is a little past 1:30. Let's adjourn for lunch. Let's come back at 2:05. Please go off the record. Okay, let's go back on the record.
Public staff calls Dustin Metz to the stand.
You want to be affirmed or sworn?
Either or.
Okay. Put your left hand on the Bible. Do you solemnly swear that the testimony you're about to give this afternoon will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Mr. Metz, would you please state your name, title, and business address for the record?
My name is Dustin Ray Metz. My title, I'm an engineer in electric section of operations and planning in the public staff's energy division. My business address is 430 North Salisbury Street, Raleigh, North Carolina.
Thank you. And did you cause to be pre-filed in this proceeding 36 pages of direct testimony plus an Appendix A with your education experience and 2 exhibits on October 26, 2021?
Yes.
Presiding Commissioner, we ask that Mr. Metz's pre-filed testimonies be copied into the record as if delivered orally from the stand, and that his pre-filed exhibits be marked for identification as shown in the pre-filed exhibits.
Without any objection? Without objection, that is allowed.
Mr. Metz, do you have any changes to your pre-filed testimony or exhibits?
I do not.
If I asked you the same questions today on the witness stand, would your responses be the same as the answers you have pre-filed?
Yes, they would.
Mr. Metz, would you please provide a summary of your testimony?
The purpose of my testimony provided the Commission with the results of the public staff's investigation on Juno Solar's application for a 275 megawatt AC merchant power plant. Public staff recommends that the Commission deny the CPCN without prejudice and allow Juno to refile its application once it obtains a completed facility study. A completed facility study would allow the public staff and the Commission to evaluate a reasonably known impact estimate of potential transmission upgrades to maintain the safety and reliability of the bulk electric system. Juno is seeking to interconnect into a known constrained area of Duke Energy Progress transmission system and sell the output of the facility to an off-taker in PJM. Duke Energy Progress has not completed a power flow analysis or any other interconnection study, and Juno's proposed condition fails to address the magnitude or total cost of the required upgrades to allow interconnection of Juno or a combination of multiple projects. The public staff disagrees with the characterization of the cluster study process as a catch-22. It is simply a business decision that the applicant has to make, like other generating facilities participating in the Transition Cluster Study, TCS, or Definitive Interconnection Study Process, DICES. The TCS is a voluntary process for the transition from serial studies to large-scale cluster studies approved by 2 state commissions and the FERC. Under the TCS process, which Juno has entered into, the applicant does not need a CPCN to progress through the TCS process. Juno will have the opportunity to apply for a CPCN once the upgrade costs are known. Should that be contested proceeding that impacts the timing to start the construction of the facility, Juno also has the right to file a request of limited construction. The levelized cost of transmission metric, aka LCOT, is not a pass-fail test. LCOT is a factor to be considered along with other factors like the total magnitude of cost and potential impacts to the transmission system, a position that the public staff has consistently taken in testimony in multiple other merchant plant CPCN dockets. The need for the power in the state and the region must also be balanced against the cost and the long-term planning for the state as the Commission considers whether a facility meets the public convenience and necessity pursuant to North Carolina General Statute 62-110.1. I listed in my testimony the applicant's proposed condition of a $4 megawatt hour LCOT rate impacts to North Carolina retail and wholesale. See my testimony, Met's Table 2. While Table 2 is illustrative to see that the rate impacts of approximately 0.09% North Carolina retail impact and a 2.29% wholesale impact, noting that this rate impact does not factor in the total magnitude of other projects that may seek interconnection in the first ever transitional cluster study process. Fundamentally, the
Public staff believes that the applicant is seeking a certificate too early in the process. The public staff first proposed a stay until the costs are known. The commission denied the request for a stay, and we believe the next best alternative is denial without prejudice. Juneau is the only merchant plant in the TCS seeking a CPCN at this early stage, and we believe that the commission will be in a better position to evaluate the application once the interconnection study results are available from the TCS. This completes my summary.
Thank you, Mr. Metz. The witness is available for cross-examination.
Good afternoon, Mr. Metz.
Good afternoon.
So, Mr. Metz, counsel for the public staff in the cross-examination of Mr. Levitas and Ms. Miller discussed some filings that were made before this commission and before FERC regarding Q reform. Do you recall that?
Yes.
So they referenced the this commission's approval in the E100 sub 101 docket of Q reform.
Yes.
And also FERC's order approving Q reform, the Duke's FERC jurisdictional Q reform process. Is that right?
I'm generally aware of them, yes.
Okay. So would you agree that CPCN procedures for FERC jurisdictional projects were not at issue in the E100 sub 101 docket?
That is correct. My general understanding of the transitional cluster process, whether it was the NCIP or the LGIA or LGIP, the CPCNs was not a consideration. The consideration was how to transition the queue.
And the changes to the procedures that this commission considered in the sub 101 docket related solely to state jurisdictional projects, right?
That is correct.
Okay. And wouldn't you agree that FERC would have no business weighing in on issues related to the issuance of CPCNs by this commission?
I can't speculate on what FERC evaluated.
Okay. Well, would you agree that it's not within FERC's jurisdiction to rule on the procedures for issuance of a CPCN by this commission?
Objection. I don't think the witness should have to speculate on FERC's jurisdictional limits.
All right, fair enough. Let me ask you this. It's not the public staff's position that because the solar industry, CCBA, supported Duke's Q reform proposals before this commission and before FERC, that Juneau Solar should be barred from raising this catch-22 issue in this docket, is it?
My testimony is not preventing Juneau from raising this supposed catch-22 issue.
Okay, so it's not the public staff's position that CCBA's support for the Q reform proposals prevents Juneau Solar from raising what it believes is this catch-22 issue in this docket. Is that right?
Are you asking, sorry to ask a question on a question. I'm trying to seek clarification.
Sure.
Are you asking what was discussed during the stakeholder process, or are you asking what's before in the application?
Not at all. I'm just trying to understand the public staff's position on this issue. Does the public staff maintain that because CCBA supported and other members of the industry supported Q reform proposals, that Juneau Solar shouldn't be able to raise this supposed catch-22 issue in the CPCN docket?
I mean, it's their application. They can raise what they want.
Okay, thank you. So, Mr. Metz, you testify that you do not believe that Juneau Solar has demonstrated a need for the facility. Is that right?
Did you point to exactly in my testimony?
Sure. I can point you to page 28 of your direct testimony, of your testimony.
Thank you. 1 second. So yes, on bottom of page 8, after 14, lines 14 through 16, taking in context the entire question and answer starting on line 4 through 13. Yet based on my review, the PJM connection queue, the applicant has not demonstrated a need for the facility or that it has to be located in the DP service territory to serve PJM.
Okay, well, let's take the first part of that where you say that the applicant has not demonstrated the need for the facility. What's your basis for concluding that the applicant hasn't demonstrated the need for the facility?
Well, an emphasis that facility is uppercase, so it's a saying the Juneau facility specifically is that given the amount of carbon-free generation within the PJM queues that I've reviewed in other EMP applications, there are numerous amounts of other generation that can serve what PJM has identified as energy and capacity needs.
So what I'm hearing you say is that there are plenty of carbon-free projects in PJM's queue, and so this facility is not necessary?
Not saying it's not necessary, I'm just saying the amount of energy that could be procured could also be procured from other resources. It does not have to be solely from this project, this facility within the DEP service territory.
So because, I'm trying to understand, so is it your position that because the Juneau facility is not the sole viable source for carbon-free generation in PJM, there's not a need for it in PJM?
I mean, I believe I stated earlier was that there is a need for energy and capacity in PJM. However, PJM has not identified that the only place that they can get it from is this facility or Juneau Solar.
Well, PJM itself doesn't identify needs for capacity comprehensively, does it? I mean, it's a market, isn't it?
It is a market, that is correct.
Okay, so would it be fair to say that it is buyers within PJM who identify needs for energy and capacity?
I'm just getting hung up on a little bit on the context of the word need. If to the extent that if a buyer wanted the energy or capacity for their carbon reduction goals, then it would facilitate a market decision.
Okay, so if there is a market decision to procure energy and capacity from this facility, would you agree that there is a need for the facility?
Based upon my understanding of the applicant and the non-binding, being careful because the non-binding agreement, that there is a need for carbon-free generation.
Okay, so it's your understanding that there's a need for carbon-free generation. Is there a need for this facility?
I believe my testimony has answered this.
Okay, but you do agree that there is a demonstrated need for energy and capacity in PJM, is that right?
That is correct.
Okay. So the public staff has considered Cpcn applications for a number of other merchant plants that plan to sell into PJM. Are you familiar with those?
Yes, I am.
Okay, so these would include the Timber Mill Wind project in EMP-118, is that right?
That is correct.
Okay, and that would include American Beach Solar?
That is correct.
Okay, just to name a couple of them. So would you agree that in each case where a merchant facility has announced its back up, would you agree that where merchant facilities applying for CPCNs have stated that they intend to sell into PJM, in every such case, the public staff has either agreed that there was a demonstrated need for the facility or not taken a position on the need issue. Do you agree with that?
Yes, and we did not recommend denial of this facility based upon the need element. We recommended a deny without prejudice based upon the facilities coming in too premature, and the public staff would need to evaluate the transmission cost once the incumbent utility or the transmission owner, in this case Duke Energy Progress, completed their power flow analysis.
Okay. Understood. We'll get to that, but I'm really trying to focus on your conclusion that there is not a demonstrated need for the facility. Prior to this proceeding, the public staff has never taken the position that a merchant plant selling into PJM has not demonstrated a need for that facility. Is that right?
I'm trying to go through the multiple EMPs through my head, and especially the ones that I've filed testimony on, but subject to check, yes.
Okay. And the commission has granted CPCNs to merchant plants that intend to sell into PJM, hasn't it?
I cannot recall all the EMP applications, but yes, I do believe there are some.
Okay, and so would you agree that in the Edgecombe Solar case, the commission granted a CPCN based in part on the fact that Edgecombe Solar was planning to sell into PJM?
Yes.
Okay, and the same can be said of the Fern Solar application? Is that right?
Subject to check.
Okay, and the same can be said of the Halifax County Solar application, is that right?
That is correct.
And more recently, the commission concluded that the Oak Trail Solar project had demonstrated a need based on sales into PJM, is that right?
Subject to check.
So in short, I mean, wouldn't you agree that in the eyes of both the public staff and the commission, up to now, merchant plants selling into PJM have consistently been able to demonstrate a need for the facility?
Up to now, for the projects that have tried to sell into PJM have been located within the PJM footprint. So this facility created a extensional wrinkle when it is a project trying to locate within Duke Energy Progress and then sell the energy into PJM.
Okay, well, this is getting to something important. I'm trying to understand why in prior cases, the public staff has always supported, or at least not opposed, a showing of need. And in this case, the public staff has come to the conclusion that there's not a need for the facility. And what I think I'm hearing from you is that there's not a need for the facility because it's located in DEP. Is that an accurate characterization of your testimony?
No, accurate characterization of my testimony is on lines 14 through 16. Based on my review of the PJM interconnection queue, the applicant has not demonstrated the need for the facility or that it has to be located in DEP service territory to serve PJM.
Okay, so is it your testimony or your view that you're not contesting that there may be a need for the facility's output in PJM? It's just that it hasn't shown that it needs to be located in DEP?
That's a fair characterization, yes.
Okay. On what basis have you concluded that the facility needs to show that it must be located in DEP to serve that need?
Well, in part of the evaluation, we'll be looking at the overall transmission impacts to the system. So in this particular case, Duke Energy Progress, through the crediting policy, Duke Energy Progress ratepayers would ultimately be responsible for any transmission upgrades that need to take place or their allocation through TCS accordingly. So again, this creates a unique circumstance when to evaluate the overall project.
Okay, so I think I'm hearing you say that your position on need is driven by the fact that Juno may trigger upgrades that would get reimbursed by DEP's ratepayers. Is that right?
Not solely, no.
Okay.
But the facts and circumstances on this specific application is that they are locating within Duke Energy Progress.
Okay, so is it the location of the project within DEP that drives your conclusion about the need for the project?
Not in isolation, no. Or if the project was located within PJM, the project could direct sell to PJM, just as the other EMPs that you have made mention of. And then the aspects of it having to evaluate the transmission system, regardless of which utility is responsible for, may be somewhat minimized with the factor of affected system studies, of course.
Okay, well, let me ask it another way. Why should the commission care whether this facility is located in DE? Well, back up. With regard to the issue of need, what is the relevance of this project being located in DEP or in PJM if it can sell into PJM either way?
I feel like I've answered this 3 or 4 times now.
Okay, well, bear with me because I'm slow learner. I'm sorry, go ahead.
No, it's just the application, the applicant, Juno Solar, did not demonstrate that in order to serve PJM's forecasted needs, it has to come from the Juno facility. And the public staff did not recommend denial based upon need. This is an observation.
All right, let me ask it another way. If there was no possibility that there would be reimbursable upgrades for the Juno project, would you have found that there was a need for the project?
The public staff would still evaluate the transmission impacts regardless of whose cost responsibility they are.
Ms. Miller testifies in her rebuttal testimony that Juno has executed a term sheet for a large investment-grade retail and wholesale energy provider in PJM. Did you recall hearing her testimony about that?
Yes, the non-binding term sheet, yes.
Okay. And you do not, is it your position that having executed a non-binding term sheet does not demonstrate a need for the project?
It's non-binding, it can change.
Okay. Are you familiar with the Timber Mill Wind project, which is currently seeking a CPCN and docket number EMP-116 sub-0?
Mr. Thomas was the lead engineer from the public staff. I'm generally familiar with the overall application, but not the specifics of it.
Are you aware that in that case, the public staff found that there was a demonstrated need for the project, even though the project did not have a contract for the sale of its output?
I would have to defer to the testimony or what's in the record.
Okay. So in her rebuttal testimony, Ms. Miller testifies about the transmission charges that Juno Solar will have to pay to wheel its output into PJM. And did you hear the testimony on that this morning?
Yes, I did.
Okay. And merchant projects that are located in PJM do not have to pay those charges to DEP, do they?
So if a project is located within PJM and they are not wheeling through Duke Energy Progress, then no, they would not pay Duke Energy Progress a wheeling charge.
Okay, thank you. And even if projects in PJM triggered upgrades, affected system upgrades on Duke's system, they still wouldn't have to pay transmission charges to Duke. Is that right?
If your question was they would not have to pay wheeling charges, that would be correct, because if in terms of an affected system, depending on how everything going on with American Beach and the appeals
Right.
and all that, and Duke's oath on reimbursement, they could pay the transmission costs depending the outcome of that appeal. But the wheeling charge, there would be no wheeling charges.
Well, they could pay the costs, the upfront costs of those upgrades. Is that right?
So clarification, if we are talking about the affected system element of a PJM project into affected system on Duke Energy Progress with a executed affected system operating agreement, which has the milestone provisions within it, the applicant would pay Duke Energy Progress those costs, and after commercial operation and upon mutual agreed upon terms between Duke Energy Progress and the applicant in that case, there would be a reimbursement or, is my understanding, a potential transmission credit.
Okay, okay, thank you. But no wheeling charges of the kind that Juno is going to have to pay to Duke. Is that right?
That is correct.
So Ms. Miller testified that Birch Creek projects that Juno will pay more than $275 million in wheeling charges to DEP over the life of the project. Would you agree that those revenues provide a benefit to DEP and its ratepayers?
So the wheeling charges and the wheeling charging revenues, or through the ATRR revenues, is slightly complex. I'm going to try to answer it the best of my abilities from an engineering perspective. I'll greatly defer if the commission had further questions from an accounting perspective, that the public staff would make those resources available, or even Duke Energy's. I am not an accountant. I get a little bit lost in the revenues and how they flow, so I'll try to answer it to the best of my abilities. So through the wheeling charges, the one element that created some difficulties in calculating it, well, first and foremost, the public staff initiated discovery on this because we thought there would be, or could be, a revenue to ratepayers to potentially apply against or offset the LCOT. So this was initiated just like we do an avoided cost. We try to find increments and decrements. As we all know, as the interconnection process continues to evolve, so does our understanding of the overall process. So we evaluated the wheeling charges and sought discovery from the applicant on this matter. So one element that started to create some complexity in evaluating this was the optionality of the project. as we heard today, is that, well, on one hand, they could sell into PJM. Well, under that hypothetical, I'll come back to non-firm and firm because there is a cost difference, and that can be found on Duke's Oasis website, publicly available. How do we start evaluating that? Under what revenue stream? Can I say right now that if an applicant proposed optionality, that we have a non-binding agreement, but we could do something else with it later or at any point up to execution, I found it extremely difficult to, not the calculation itself, but provide weight that would actually be a revenue offset to the overall calculation. So just optionality in itself created difficulty summarizing. Moving to the second point versus firm versus non-firm. I believe we've heard reference to public staff data request 213 and using the spreadsheet that the company provided. In that they listed 175 megawatts of what they were prescribing, not that they have to do it, not that a conditional CPCN can make them do it, of 175 megawatts, and we're able to calculate the firm point-to-point service. So yes, using the company's spreadsheet, and before I start spinning up, it's non-confidential, correct? I believe we released it, but I've heard some conflicting.
Yes, it's
Okay.
not confidential.
And I can provide this to the commission as late filed exhibit as well, with some of the public staff calculations. Under 175 megawatts, firm point-to-point, firm being that they are subscribing, that they have rights to move that energy across Duke Energy Progress systems and cannot be curtailed. That's probably under emergency conditions. Is that under 40 years? Yes. $286 million in potential revenue at the escalation rates projected and all assumptions held constant. However, one would have to evaluate the net present value of that. In other words, ratepayers today under a $4 LCOT would be $51 million. You would have to do a net present value of the potential revenues over 40 years. Going out 40 years, there's a lot of assumptions. It's a lot of unknowns. I'll stay away from the word risk. Simplifying discount rate, that equates to $88 million net present value with 175 megawatts firm point to point. Again, to restate, I could not give that any weight given the optionality of the project. A different evaluation that I conducted was that revenue stream from the wheeling charges was not with the upgrades of the $4 LCOT. One would need to add in the potential of the $4 LCOT, which would be $51 million. And so under the initial case would be the base case. And then one would evaluate the additional $51 million injection at year one, simplifying assumptions, and doing a net present value analysis. It went to, instead of 88.2 million, it went to 89.7 million, plus or minus. There's some assumptions in here. The base case and change case demonstrated that only 1.5 million additional revenue would be from the $51 million in upgrade costs, or approximately 1/16. Again, increment and decrement that the public staff has evaluated consistently in multiple dockets. The second part of the evaluation was looking at the non-firm, because again, the application as proposed did not say whether it had to be firm or non-firm. The applicant could elect to do non-firm using the same assumptions of 40 years. And by the way, I've done this at 15 years, 20 years, and 30 years. The simplifying assumptions with non-firm, the revenues drop in half to approximately 42 million versus the approximately 88 to 89 million. I know it's a little bit long-winded answer, but on the wheeling charges, there was a lot to discuss there in the conversation.
And Mr. Snowden, while you think of that, if you will, provide a late filed exhibit. Thank you.
Certainly.
Let's unpack. There are a couple things to unpack in your answer there. The first thing that stood out to me was that you said that you calculated based on Juno's allocation, their statements about the purchase of firm transmission, that the net present value of that $275 million or so would be either 88 million or $89.7 million. Is that right?
Approximately with the given discount rate at 40 years if all things manifest themselves.
Okay. So that is higher than the 50 or so million dollars in upgrade costs that would correspond to the $4 LCOT. Is that right?
That is higher with the caveat that that is under assumption that they would do firm point-to-point service or non-firm point-to-point service over the entire contract length. That they could elect at a different point in time, say at 15 years or 10 years, again, because it's a non-binding term sheet, a different term sheet can be elected into tomorrow. I can't speculate on that nature, but yes, that's why I evaluated at different term lengths.
Do you have any reason to doubt that they would continue to purchase firm transmission service over the life of the project?
Well, I thought I heard today that you evaluate potentially selling I read in the application that you evaluate or even through discovery that you could sell at any time to Duke Energy Progress as an off-taker or outright sell the facility to potentially Duke Energy or Duke Energy Progress. So yes, I do have reason to doubt.
Okay. But would you agree that if the project were sold to Duke for compliance with, for purposes of meeting the HB 951 goals, that's just an entirely different set of benefits that we'd be looking at, isn't it?
That is, and that's a great question because under that, ratepayers would no longer be receiving the wheeling revenue to potentially offset the transmission costs.
Okay. I also want to go back to something else you said. You calculated that out of the 88 or $89 million in wheeling charges, only $1 million or so of those charges would go to paying for the upgrades associated with the facility. Is that right?
Under one scenario, looking at the potential, if you would look at the incremental contribution, under that concept, then yes, it would only be 1.5 million, but there are multiple assumptions embedded with that, and that may not be the most absolute value to hang your hat on.
Okay, but some portion of the rest of that would go to fund either other upgrades to Duke's system or other capital investments, past or future, in Duke's transmission system, wouldn't it?
And that is true. And with the further clarification is that not just all of the costs through the OAP are for capital. I do not know the percentages, but they are O&M, overhead, and other capital expenditures.
Okay.
And capital expenditures.
Okay. Projects that are located in Duke's service territory that sell to Duke do not pay transmission or wheeling charges to Duke. Is that right?
You say it again, please.
A project that is located in Duke's service territory and that sells to Duke does not pay wheeling charges, right?
It is my understanding if facility hypothetically is located in Duke Energy Progress and direct sales to Duke Energy Progress, then no, there would be no wheeling charges.
Thank you. So Juno Solar has requested that the commission approve its CPCN subject to a condition that if the LCOT of upgrades associated with the project exceeds $4 per megawatt hour, the CPCN will terminate. Is that your understanding?
Yes, that is my understanding.
Now, in your testimony, you do not take any position on the question of whether an LCOT of no more than $4 per megawatt hour is reasonable, do you?
I do not take a position because the position of my testimony is that in order for me to provide a recommendation to this commission that I need a completed facility study with best estimate transmission costs from the transmission owner in order to make the evaluation, noting that even those costs, like we saw in Frisian and like we've seen in other EMP applications where I filed testimony, those costs go up and down through multiple times. And even as we had in discovery in this particular case on your project, public staff data request number 2, looking at question number 7, we asked the question, what class or level estimate would you consider the $16.84 million estimate? What is the tolerance and range of that estimate? This is a planning or budgetary class estimate based upon the reasonableness and assumptions in line with utility practice and industry standards. This estimate is to have a -20 plus 100 variation. These are still preliminary estimates. We accept that there are estimates, but however, like I've tried to say, and we said in testimony, I need a completed facility study from the utility, noting that we will have to evaluate those costs at that time and understanding the risk associated with some of those potential upgrades and the level of class estimate. And like I've done in other EMP testimonies, that we will evaluate a range of potential outcomes of magnitudes of cost to evaluate the benchmark and reasonableness on the LCOT metric, which is inclusive of evaluating the magnitude and the nature of the upgrades in themselves.
Isn't Juno Solar asking in this case that the ultimate fate of its CPCN will be determined by the LCOT as shown in the facility study for the project?
So the applicant is requesting, and through, I believe, different clarifications of testimony, because the position has morphed over time or evolved slightly, that the applicant is agreeing that $4 LCOT all-in cost is if it goes over that, then they'll withdraw or revocate their CPCN. That is my understanding of the applicant's request.
Okay. And is it your understanding that Juno is not asking the commission to make a judgment as to what the actual LCOT of the project is based on its current estimates, is it? Let me ask it another way. Juno has asked that the commission set a $4 standard for LCOT for the project, right?
That is correct.
Right. And compliance with that $4 standard is to be measured based on the results of its facility study. Is that right?
I don't know if it was designated that the facility study would be actually setting the benchmark as pass or fail, because that creates another unique issue with the termination provision as proposed, and the conditions become, it's not problematic, is not the right word, it's just, becomes very complex to try to solve for, to the extent that the applicant is requesting that the execution of the interconnection agreement should terminate the revocation provisions through time and other factors. Estimates change and those costs could go up.
Well, let me ask you this, though. You are not taking the position that the commission should be able to revoke a CPCN based on what the post-construction actual costs of interconnection are you?
No, I'm saying at this time, if we looked at the timing of it, again, we do not have a completed facility study with a level or range of estimate or valuation of even what the upgrades are. I would have to evaluate the upgrades, the execution of the interconnection agreement, and the types of upgrades, because I remember testifying this on Frisian, and part of the conversation was the multiple river crossings associated with Frisian. Each river crossing, from a project management standpoint and a construction standpoint, is embedded risk. I can't make an informed decision on whether or not the terminating provision should indeed be the IA with the balance of the actual estimation. Because until you put boots on the ground, you don't know what you're going to run into. So if we did a paper version of a evaluation to base the LCOT off of, and the metric and all these conditional functions that we want that the applicant's trying to request, one may need to evaluate whether that is appropriate in that unique set of facts and circumstances.
So are you telling me that you don't necessarily trust the estimates that are prepared by Duke's interconnection teams for purposes of the interconnection agreement?
No, it never came out of my mouth.
Okay. Well, I'm asking you, what I think I'm hearing you say is that, well, there's a lot of uncertainty with these IA estimates. The Duke's teams may not have appropriately accounted for risks. I would need to review that myself to determine whether that estimate is reliable. Is that your testimony?
As I'm representing the general consuming public, yes.
Okay. So if you had an interconnection agreement in your hand that said the cost of these upgrades is however many dollars equals a $4 LCOT, even at that point, the public staff could not reach a conclusion as to whether the LCOT for the facility was reasonable?
So it starts to become very challenging because, for example, if the $4 LCOT, so I believe the testimony listed that approximately the applicant, through their power flow analysis, estimated that around 17 miles of transmission line will have to be upgraded. I mean, we have seen in other system impact studies within PJM on new EMP applications triggering what they called wreck and rebuild. That basically we could have just invested millions of dollars, hundreds of thousands of dollars, who knows what the cost on a line for a reliability upgrade last year, 2 years, 5 years, etc. But then a project comes on and says, hey, we need to wreck and rebuild that, not for reliability, because the existing system is okay, it's working, it's per NERC standards, and we need to rebuild that line. So ratepayers we expose to the undepreciated cost of the existing line, plus now the incremental cost. So again, one needs to evaluate exactly what the transmission upgrades will or will not be.
It sounds to me like you're testifying that you don't think that LCOT, well, is it your view that LCOT is not a particularly good metric for the reasonableness of interconnection costs?
I believe it was stated earlier is that LCOT was just one tool in the evaluation of a project.
So in the Friesen docket, you provided testimony about what you thought were appropriate benchmark LCOT values for network upgrades in that case. Is that right?
If you're referencing the LBNL study, that is correct.
Okay. And the LCOT values from the LBNL study were in the range of $1.56 to $3.22 per megawatt hour. Is that right?
That sounds correct, yes.
Okay. And would you agree that since 2019, transmission costs have generally risen?
Generally, reason is somewhat vague. Just looking at markets and potential labor costs and other, there's been more upward pressure with them the last year. But yes, I would agree they have generally risen.
Okay. So let me ask you this. Would you agree that as of now, an LCOT of $4 per megawatt hour is not unreasonably out of line with those LCOT figures that are presented in the LBNL study?
That is correct. The public staff does agree that the potential of a $4 LCOT may be the correct metric, but however, until we see a completed facility study from Duke Energy Progress specific to Juneau Solar, it's premature to just say that's okay. Because one function of the LCOT, how people are characterizing LCOT, we're failing to identify the magnitude cost impact. For example, a 5 megawatt project with an LCOT of $4 has a much lower impact to wholesale in North Carolina retail compared to a 275 megawatt project. And as we can see through the TCS cluster that is potentially coming through, there's going to be a magnitude of projects, knowing that at this point in time, we're only seeing the potential of one CPCN. We'd have to evaluate the magnitude of cost.
So, Mr. Metz, what I'm hearing is that you are concerned with the overall magnitude, not just the. What I'm hearing is that you are concerned not just with the LCOT from the project, but one of the other factors you're concerned about is the magnitude of the absolute magnitude of the upgrades associated with that project. Is that right?
That is just another element, yes.
Okay. And has the public staff taken a position as to what absolute magnitude of upgrades associated with a single project would be reasonable or unreasonable?
No, because I tried to clarify that earlier on. It's also an embedded function of what the upgrades actually are. So for example, if under one hypothetical, if it's a wreck and rebuild of a new line we just got done building, we would need to take that in overall consideration. It may not be a failing criteria, it may not be a passing criteria. It's just something that has to be taken in consideration. And these transmission studies are, in these projects, are all unique in nature.
Well, let me ask you this. In prior merchant plant CPCN dockets, has the public staff taken a close look at the exact nature of the upgrades at issue when in his recommended approval of those CPCNs?
1 second. So it might serve the commission that we answered this question and a data request from the applicant in DR1. Specifically question 8. Question 8, public staff witness met states that the commission cannot make a full informed decision on the application until it's been studied. Fast forwarding, please identify all CPCN proceedings, including applications for utility construct facilities, which public staff has taken a position that the commission should not render a decision. So in that response, I go through each one of the applications, inclusive of EMPs and utility-owned generation. I'm not going to reread it. I mean, we're happy to provide the commission this response unless they want me to go in more detail in each one of the dockets.
Looking at these,
Mr. Snowden, if I could interrupt, we would like that in a late filed exhibit, please.
actually, Commissioner Duffley, I can go ahead and request that this data request be marked for identification as applicant's cross-examination exhibit 1. So that we can
marked.
see it, yeah.
And let's mark that Met's cross-examination,
Yes, ma'am.
number 1.
I got it.
And then looking at how we've marked the public staff, we'll call it the Juno Met's cross exhibit number 1, keep consistent with the public staff records.
Okay, so Mr. Metz, has everybody got a copy of that now? Looking at the public staff's response to data request 8. There are several dockets here, with the exception of the EMP-92 docket. These are all dockets relating to CPCNs for utility constructed or approved units. Is that right?
That is correct.
Okay. And would you agree that the utility has got a much greater access to information about the nature of the upgrades that would be required for a facility than an interconnection customer does?
Well, I mean, an interconnection customer, once they have a completed system impact study and a facility study from the utility, they should have a degree of insight into the overall upgrades. My apologies, I am looking for the EMP applications. Oh, exactly. So on page 12 of my testimony, we also go into great detail, especially footnote 9 of the multiple EMP applications. So my apologies, Mr. Snow, I only answered the utility owned and not the merchant plant aspect in the previous question.
Okay. Well, I was just asking about the utility owned ones. So referencing your footnote 9 here on page 12 of your testimony, that references instances in which the public staff has requested that additional information about costs, network upgrade costs, be provided to the commission. Is that right?
That is correct. And as you can go to the PGM website, on each one of those individual EMP applications, you can see the completed, there's 3 studies on a mixed. I forget the first one, it's FC, but then system impact study and then the equivalent facility study. And some of the conversations that we've had in the previous EMP applications, explicitly EMP-102 sub 1, which is before this commission, there's been multiple filings in that testimony, so I lose track of which one. But at one point in that time, is the public staff could not make a recommendation similar to Juno Solar, is that we did not have a completed effective system study for the second part of the overall project, which is, in my opinion, almost identical to what is going here before Juno. We just cannot make a recommendation on a cost that we don't know what it is, or the nature of the upgrades that we don't know what it is.
So you believe that the commission needs to have complete information about all the upgrades that will be required for a project before a CPCN can be granted?
I believe the facility study is the utility's best effort to provide insight in the nature and the cost of the upgrades.
So Mr. Metz, you also say in your testimony that it's the aggregate cost to ratepayers of upgrades in the transitional cluster study that's important. Is that a fair characterization of your testimony?
I don't know if I said important. If you can point to point your reference.
I'm afraid I don't have a citation off the top of my head here. Would you agree that you testify that the commission must consider the aggregate cost of all of the upgrades triggered by the transitional cluster study before it can act on Juno CPCN?
Similar to when I was looking at the on impact rates, specifically on page 30 on table 1, and then the results on table 2. I believe the public staff would, and I believe the commission would also evaluate the total rate impacts in whole. So when one evaluates certain particular projects, the rate impacts could go up, and in other circumstances, they may not.
So let me ask you this, because I'm trying to understand how this is going to work, or how the public staff sees this as working. So if a group of projects in the transitional cluster were to collectively impose upgrade costs that the public staff believed were unreasonable, should the commission just deny CPCNs for all of those projects?
My immediate answer would be no, with the caveat that that's sort of an open-ended question, because I would have to know the nuances or the specifications of each individual project. For example, if they are state jurisdictional projects seeking CPCNs or interconnection through the TCS, those costs would not be borne by ratepayers. They would be borne by, for lack of a better word, the market participants or the individual investor.
Well, let's limit it to just for jurisdictional projects whose upgrade costs might be reimbursed by ratepayers. If a group of FERC jurisdictional projects in the transitional cluster collectively resulted in upgrades that the public staff thought was unreasonably large in the aggregate, what should the commission do with that information? Should it deny CPCNs to all the projects that it has before it?
One would have to evaluate the overall project, because under that potential hypothetical, that is the assumption that all the projects are independent. There could be again, hypothetical, that there may be non-project interdependencies, 2 projects on opposite ends of the system, or even near part of the system, depending on the injection of where they're putting out on the topology of the system at that given time. They could be not interdependent, and they could be viewed in overall isolation. But again, in DEP for North Carolina, there are 2 FERC jurisdictional projects, and only one is seeking a CPCN right now for the Utilities Commission.
So what I think I'm hearing you say is that this commission, in considering whether to grant a merchant plan CPCN, should undertake to review not only the cost, but the complete nature of the upgrades that might be triggered by a proposed merchant plan. Is that right?
It should be taken into consideration, yes.
And that the commission should also review not only the aggregate cost, but the interrelationships among the different projects that might all trigger upgrades in the same cluster. Is that right?
It is potential, yes.
That seems like a lot of work. Is that,
So, but before is it's 2 projects in Duke Energy progress seeking FERC jurisdictional interconnection. I don't know how to classify that as a lot of work.
well, so let me ask you a follow-up question, though. Speaking of the aggregate amount of upgrade costs that might be imposed in the transitional cluster, is there a number, is there a cost, an aggregate cost number that the public staff would deem unreasonable for upgrades coming out of the TCS?
Could you clarify on, again, as I stated earlier, is when you're looking at SP projects, it's done under a slightly different lens comparative to.
I'm sorry, just for jurisdictional. Ignore the SPs. We don't care about those right now.
Thank you. So can you repeat the question, please?
So solely with regard to FERC jurisdictional projects, upgrades that might be ultimately charged in part to North Carolina retail ratepayers, is there an aggregate number that the public staff would consider to be too much, to be unreasonable?
Well, again, we believe that the concept of the LCOT is correct in nature, and it is a possibility once we have the completed facility study from Duke Energy Progress that even the concept of a $4 LCOT may be approved. I cannot make that approval at this point in time because, again, one has to evaluate the facts and circumstances at that particular point in time for that particular application, or as to the possibility of a cluster study process, one might need to take a step back and look at it more of a holistic evaluation explicitly when we're starting to look at potential outcomes of the carbon plan that will be implemented in the coming years.
All right, I want to think about the logistics of requiring a facility study before a merchant plant can submit a CPCN application. So Juneau is interconnecting under the OAT, not the North Carolina GIP, right?
That's correct.
Okay. So under the OAT, the LGIA, the interconnection agreement, has to be delivered to the customer within 60 days after receipt of the facility study. Is that right?
Subject to check. I've read over the LGIA. I don't have.
You haven't memorized it?
I have not memorized it. I have reviewed it. I have aligned the time periods between that and NCIP, but subject to check.
Okay, thank you. I had to reread it last night, so I have not memorized it either. So in the transitional cluster, the customer has to execute the LGIA within 60 days of receiving the draft IA. Is that right?
Subject to check.
Okay, so the customer has a total of 120 days from delivery of the facility study to execute an interconnection agreement.
Up to, yes.
Okay, up to. And signing the interconnection agreement obligates the customer to pay the upfront cost of interconnection facilities for the project and also upgrades. Is that right?
The executed LGIA, yes, it's an agreement between the utility and the applicant, where I lose track of. I've been spending a lot of my energy here lately on affected systems. I don't know if FERC has to approve that. I don't know.
I'll represent that if you've used the pro forma, it just has to be filed, not approved.
Okay, thank you.
So it's the public staff's position, though, that the commission denied the Juneau CPCN without prejudice, and that Juneau not be able to refile its application until after it has received its facility study and also any affected system studies. Is that right? And I can direct you to page 6 of your testimony if that's helpful.
Let me point to exactly what line.
Sure. So on lines 5 through 9, you say, I recommend that the commission deny the CPCN without prejudice, allowing the applicant to refile its application once it has obtained its facility study report and once any applicable network upgrades assigned from affected system studies are known. Did I read that correctly?
That is correct,
Okay.
because that will enable me to initiate the investigation process to evaluate the upgrades, the nature of upgrades, have conversations with the impacted utility, and as well as the applicant, similar to how we had conversations in discovery and freezing.
So as we discussed, under the oath, the customer has 120 days from the issuance of its facility study to execute its IA. Is that right?
Up to, yes.
Okay. In your experience, is it typical for the commission to issue a ruling on a merchant plant CPCN application within 120 days of it being filed?
I'm not cognizant of the dates on.
Okay. Well, do you recall an instance in which the commission has granted a merchant plant or has taken action to deny or grant a merchant plant CPCN within 120 days of it being filed?
I'm not cognizant of the dates, but I'm trying to understand the relationship between the execution of the LGIA versus the CPCN. Those are, well, I know it's making a linkage. They don't have to be on the same track.
Okay. Well, let me ask you this. It's not really practicable for an interconnection customer to get its facility study, prepare a CPCN application, file it, and get a ruling from the commission on its CPCN within 120 days, is it?
I think it was something that had to be taken into consideration, and the applicant could make notification to the commission to take into consideration, not for an accelerated timeline, but a concept of potential priority given whatever is before the commission at that time.
So you could ask for a ruling within 120 days. Is that what you're saying?
That's correct.
Okay. But
And I think this is a dynamic function of the TCS process, something that we're still learning through.
But there's not a process in place that would allow a merchant plant to get a CPCN approved or denied within 120 days, is there?
I would have to go back and reread. I don't know if there's a timeline that's preventing something to be truncated. I don't think it says that you have to wait 180 days until you get a ruling.
Well, the commission's got to, there are certain specified timelines such as the 10-day completion deadline, public notice periods, clearinghouse review, time for testimony, time for hearings if necessary, and all that, right?
That is correct.
Okay, and it's more typical for a CPCN application to take at least, say, 6 months or more than that. Is that fair characterization?
Potential or one-off anomalies, but usually those were mandated by law.
Okay, so it seems to me extremely unlikely that if a merchant facility weren't able to file its application until after it got its facility study, that it would receive a ruling on its CPCN prior to entering into its IA. Would you agree with that?
Generally agree. And then when looking at the statement on page 6 and turning over to page 4, footnote 29, sort of laid out the timeline here for this very concept. When one looks at the issuance of the facility studies and the potential individual restudies throughout the process, one can see that the multiple 150-day blocks along with prospective timelines, which if the LGIA takes up to 120 days is well within the 150 days.
Okay, I'm sorry, Mr. Metz. I did not catch where it is that you're looking.
Oh, sorry. Page 34, footnote 29. So through that footnote, where it was generally laying out for illustrative purposes to see the different times of when study reports would be issued, the potential complexities of restudy, but in each circumstance, the window open for each individual one. We believed it was appropriate that even given with the up to 120 days, that there would be time to perform this process under the nature of the TCS process, which was to clear the logjam. I believe it was said today. It was to remove the speculative nature of certain projects and advance commercial ready projects.
Okay, but I'm looking at footnote 29, and there's no reference to the deadlines for executing an IA here, are there?
That is correct. It
Okay,
is
it's this process you've laid out ends in facility study, right?
the individual individual facility studies, 150 days, September 27th, 2022 through February 24th, 2023. Then issuance of facility studies, and again, in conversations with Duke, this is sort of the back end, if you would. This is sort of the up to. They may be issued before, and then phase 3 restudy with the additional timeline requirements.
Okay, so you're saying Juno, come back in maybe February 2023 and file your application then? Is that right?
Give or take upon the issuance of a facility study, yes.
Okay, so upon receipt of an application for a CPCN for a project that may have already signed an LGIA, the commission could decide to deny that application, couldn't it?
The commission could, or they could accept.
Okay. So fundamentally, the interconnection customer, the merchant facility, does not know whether the commission is going to grant or deny its CPCN when it files its application, right?
That is correct, and I can't make my recommendation to the commission until I see the actual facility study cost by the incumbent utility.
Okay. So is it your belief that a merchant facility should enter into an LGIA and commit itself to funding millions of dollars in upgrades and interconnection facilities without knowing whether this commission will allow it to be constructed?
So there's two concepts here. There's the TCS process, and there's what comes after the TCS process, which is often just referred to as the DICES. Again, the TCS process and the milestones and the increased payments were completed through a negotiated stakeholder process, which TCS process had higher costs comparative to DICES for the concept of, as the word has been used today, clearing to logjam, to remove the degree of speculative projects and move forward commercial ready projects. That was all agreed upon through a stakeholder process by two commissions, two state commissions, and the FERC.
Okay, I'm going to ask my question again. 'Cause I'm not sure I heard the answer to it. Is it your belief that a merchant facility, either going through TCS or going through DICES, should should be required to enter into an interconnection agreement without knowing whether the commission will allow it to be constructed?
That is a financial risk of the applicant.
So yes.
They have to evaluate the costs or the cost uncertainty at that given point in time.
Okay, so you think,
And I can't speculate on what the applicant would or would not do. So I apologize. I'm not trying to dodge your question. It's just I can't say what the applicant would or would not do in execution of LGIA. It's just one has to evaluate the knowns and unknowns, and that's in my opinion a business risk that the applicant would need to take whether they want to execute the LGIA. In theory and speculation, one could enter an LGIA and while waiting for the facility study. If they have a strong understanding of what they believe their transmission costs are, they can enter what they want to enter into. I can't control that.
okay, but in the absence of guidance from the commission or the public staff on what level of costs are reasonable, how does an interconnection customer make a decision whether or not to enter into an LGIA when they have no idea whether their CPCN is going to be granted or denied?
Mr. Snowden, that's been asked and answered
Okay.
a couple of times.
Well, let me ask you this, Mr. Metz. So when an LGIA is executed, the utilities interconnection teams will commence doing engineering work and procuring long lead time materials and ultimately constructing the facilities and upgrades. Is that right?
Per the milestone agreements, for example, one of the items that we noticed in Frisian was the multiple years that it would take for the constructions of certain not critical energy infrastructure, but just critical parts of the system that can only be worked on during certain parts of the season. So that would have to be a factor in that agreement, would be the timeline.
Okay, so Duke's personnel should go ahead and commence work on interconnection without knowing whether the project will actually go forward?
That is a business risk that the applicant will enter into with the incumbent utility. That is a business decision between those two parties.
Okay. Do you think that is a good use of Duke's limited construction resources?
If the milestone agreements are to keep Duke Energy cost neutral, when I say cost neutral is they will not expend X amount of cost or resources without being reimbursed, that is a risk-based decision to keep them indifferent.
Okay, understood that Duke may be indifferent to the cost, but would you agree that Duke's own personnel resources are not infinite?
That is correct.
Okay, and that there is in fact a bit of a crunch on Duke's engineering and construction personnel and has been for the last several years?
I can't define crunch, but also know there's been an increase in staffing to address these potential situations.
Okay. Is it your understanding that once an IA is signed, subsequent DICES clusters will rely on upgrades that are committed through an IA in the baseline for the next study?
I'm just trying to go through my mind of saying, okay, is the baseline the actual IA? Because a function of the baseline is the base case, which is already considering future upgrades that are already in the works. So it's not solely based upon the IA. I do not know if it explicitly encompasses the IA or not.
Okay. Well, let me ask it another way. Say you've got the DICES 2023 cluster, and Duke is establishing the base case for that. It's going to consider upgrades that were allocated and committed in the DICES 2020 in the previous year cluster, right?
Yes, a function of the future DICES would always be the base case of the, trying to get my vocabulary right here, whatever the entered in contracts with the previous cluster agreed to pay for.
Okay. So wouldn't it cause some pretty significant disruption to other interconnection customers if the commission were to deny a CPCN for a project that had already signed an IA?
It depends. It's very complex in nature because you can have some projects that will not, again, in theory, you'll have some projects interconnecting in parts of the system that would not have any upgrade cost or create these interdependencies. Under some examples, with multiple interdependencies, depending on the magnitude of the interdependencies, there could be complications. But again, complications are just challenges that we continually work and overcome on every given day.
Okay, well, let me narrow the question a little bit. Take as an example a project that does have significant interdependencies and does incur significant upgrade costs, because I think those are the kinds of projects that we care about, or that the public staff cares about. Wouldn't it be pretty disruptive to other interconnection customers and to the DICES process if the commission were to deny a CPCN for a project like that after it had already signed an IA?
But again, as I stated earlier, I believe that there is enough of a window to where once the facility study costs are known, they can be evaluated and be brought forward to this commission and potential for the commission to make their ruling on whether it should be denied or accepted prior to the next DICES window closing. Because when the DICES window opens, there's a period of time before the DICES window closes.
Well, let me ask this. Say you've got, and I'll move on, since I know we spent a long time on this. Wouldn't it cause a lot of disruption to the same cluster that the project was in if the commission were to later deny the CPCN, assuming again that the project had significant interdependencies and committed to constructing upgrades?
That's a risk with cluster studies process and with functions being interdependent. I mean, we're seeing that right now in PJM. So that is not a new process. That's something that already exists.
I understood that the risk of project withdrawals is part of a cluster study. Do you think the commission should be doing things to increase the risk of disruption based on more withdrawals?
I don't believe that we are increasing the risk. As again, as stated before, is in order for me or the public staff, presumably the commission, to make a determination of what the transmission upgrades are, we need to complete a facility study. Looking at the timelines, there is a adequate window, albeit somewhat narrow, to potentially resolve this issue.
Okay, so you say there is an adequate but narrow window after the delivery of the facility study to evaluate those costs. Is that right?
Yes,
Okay. But you also recommend that Juno not refile its application until after an affected system study is completed. Is that right?
that is correct. And that's one of the concerns that we did bring up during the stakeholder process as well. In our comments that we filed, is that the affected system study is somewhat, it's not isolated, but it is in its own parallel path without explicit timelines. So as the applicant moves through its process, for example, if a project goes into phase 1 and they get identified or hypothetically, you're locating a Duke Energy Progress, and under an affected system under phase 1, Duke Energy Progress will notify DEC, hey, you're an affected system. What do you want to do about it? So through the LGI process, Duke Energy Carolinas will say, all right, we're going to go evaluate it. Why the transition cluster and DICES are moving forward at their own pace. I mean, some of this has also been brought up in much detail through the resource solicitation cluster. Is that Duke Energy Carolinas can notify them to say, well, while you triggered an affected system, there really wasn't nothing there. It was no cost, or it was something very, very nebulous. However, what the applicant is also informed in both of phase 1 and phase 2, it's a flag. It's a risk. You have the potential for affected system upgrades. With that known risk, do you want to continue to move forward with paying your deposits and potential penalties with the offset provisions? If costs go greater than 25%, there's ways out and the penalties be waived. So yes, the affected system process does go in its own path, but it's informing the applicant, not at facility study, well in advanced facility study, phase 1, phase 2, and that's a business risk that they're making throughout the entire process.
Okay. So would you agree that there are no defined timelines for the delivery of affected system studies?
Correct.
Okay. And I believe you testified that Duke has what it calls a goal of completing affected system studies within 60 to 90 days. And I'm sorry, that's on page 25 of your testimony.
That's correct.
Okay. 60 to 90 days from when?
I would have to go back and reread the LGIA through the affected system process.
Okay. But that 60 to 90 days is just a goal, right?
It is a goal.
Okay. We have no commitments from any other utility about how long it might take them to conduct an affected system study, do we?
And that's correct. For example, if Juno Solar was to trigger a PJM affected system process, you're at PJM's discretion of when that affected system study process would or would not be completed, no different than any other potential utility.
Okay, so there's really no telling when a project might receive an affected system study?
Yes.
Okay, it could certainly be after the facility study was received, right?
It could be. Yes, it could very well be. But so in that conversation or in that vein would be, we might be able to get preliminary information and serve discovery on the affected utility to say, okay, what was the nature of the upgrade? It's a substation breaker. All right, $1 million. Okay, we can evaluate that. The explicits of it would have to be more fine-tuned through the affected system study. But if at a preliminary or high level, and we have those conversations, say, well, we really have about 55 miles of 230 kV that we need to upgrade, and we have this other section 115, yada, yada, yada. It changes the story, and the applicant will have to evaluate those risks as they move through the process. So if the applicant is notified of affected system at phase 1, they could bow out without the penalties, and that would be potentially fair isn't the right word, but the other people in the queue can continue to evaluate, because maybe that magnitude of that project was the tipping point that triggered the affected system, and the rest of the projects may be able to come under the triggering effect. So it's not going to necessarily implode. It's a function that has to be evaluated and restudied.
Okay, so your recommendation, though, is that merchant projects or that for jurisdictional customers wait until they receive their affected system studies before they file a CPCN application?
That would be consistent with the EMP applications, because I could not make my determination of what the nature of those upgrades are, nor the cost, because now we come in a potential. So let's say hypothetically, Juno Solar triggers an affected system upgrade in DEC. So public staff would have to evaluate, and it's under the FERC crediting policy. We would have to evaluate the impacts, not now just to only DEP customers. We would have to evaluate the impacts now to DEC customers for energy that is going into, again, hypothetically, not trying to single out Juno, but for, again, hypothetically, where something is getting sold into PJM.
So it's your position that an interconnection customer should wait to receive an affected system study from PJM or Santee Cooper or Dominion or a non-North Carolina utility prior to filing a CPCN application?
I think that'd be the most ideal solution. And when one considers the termination provision of the LCOT, I don't see them any different. So if under the assumption that if a merchant power plant was seeking a CPCN from the Utilities Commission and they had an unknown affected system cost, but was applied to the overall LCOT, I don't see the difference of getting a $4, in my words, a blank check, paying all the upgrades, or not paying for the upgrades, but potentially paying for the study, being exposed to withdrawal penalties, only up to multiple months down the road or years down the road, and be notified of this open-ended affected system process.
So I think you mentioned the possibility of, what would happen if Juno triggered affected system impacts on DEC. So Ms. Miller testified in her rebuttal that Juno has committed not to seek reimbursement from North Carolina ratepayers for any affected system costs. Did you hear that?
I agree with that, and that's some of the fluid nature that has been discussed over time through the testimony. So part of that would make sure, the devil's in the details. If one were to make it a condition, I think the condition would have to be explicit that the LCOT does not apply towards affected system cost that the applicant is voluntarily requesting that they pay for their own upgrades in an affected system.
So if there were a condition in Juno's CPCN that provided that Juno would not seek reimbursement for any affected system costs, upgrade costs that would be charged to North Carolina ratepayers, would that resolve the public staff's concerns about affected system upgrade costs?
In terms of the recommendation that the public staff would need to review both the facility study and the affected system cost, that may be, I would have to think on it more, but that very well may be a mitigation measure as you discussed.
Okay. And if Juno were to trigger affected system upgrades on PJM system, they would not get reimbursement for those in any event, would they?
That is my current understanding, yes.
Okay. Are there any other systems that Juno might trigger affected system upgrades on?
I have the transmission map on mine, so I'm trying to evaluate it. It would be too much speculation to make any assumptions at this time without fully understanding the sort of the base case or the potential retirements, or what they refer to as defects on what elements are turned down in the system to handle the injection of the new generation. Too much speculation.
Okay, thank you. But Juno would not in any event be getting a reimbursement of affected system upgrade costs from North Carolina ratepayers. Is that right? If it accepted the condition that we just discussed a minute ago.
Under that condition, with that explicit caveat, yes.
Okay, thank you. So let's move on a little bit. Mr. Metz, in your testimony, you discuss HB 951, is that right?
Generally, yes.
Okay, and that law requires the commission to take all reasonable steps to reduce emissions from Duke's generating fleet in North Carolina by 70% by 2030. Is that right?
In part, there's a couple provisions of that. Under certain technologies, there is a little bit of a grace period. I don't have the law in front of me. I was subject to tech, I believe it was a year or two under certain provisions. And there was one other caveat, but go ahead.
Okay. So Ms. Miller testifies that with regard to HB 951, that Duke's IRP, which the commission has now approved, shows that achieving this goal of 70% reduction would require procuring at least 9 gigawatts of solar by 2030. Does that sound right to you?
If you can point me to her testimony, please.
Sure. Page, let's see, this is her, let's see, 15, I'm sorry, I think it's her direct testimony, page 15. I'm sorry, that's her rebuttal testimony, page 15.
All right, at page 15, I believe what questions start at line 14?
Yeah, line 16 is the testimony.
So yeah, please proceed.
Okay, so she says Duke's integrated resource plan pending before the commission shows that amount of solar that must be procured to be at least 9 gigawatts, although interveners have put on evidence that would support a much higher number. Do you agree that she's appropriately characterizing the IRP and what others said in the IRP docket?
Well, somewhat confused on the, I mean, she jumped, and not on purposely, but I couldn't discern whether she was talking about the North Carolina IRP or the South Carolina IRP. I know she talks about sort of at the last line, the amount of required solar could be closer to 11 gigawatts. So that would point to me that she was referencing South Carolina's IRP and not necessarily North Carolina's IRP. And I remember the other caveat that I wanted to eventually discuss, that 951 is that the commission has to create, implement, and follow through on the clean carbon plan or that equivalent. And that would inform the steps and evaluation steps on the generation portfolio that would be into the future, which I would hope that, or at least the public staff would also be evaluating the NREL Phase 2 report, which would be evaluating the amount of potential generation resources to complement the existing system while balancing the retirement of the existing systems to maximize efficient utility build out on both generation and transmission.
Okay. Well, would you agree that based on this 9 gigawatt number that was included in Duke's North Carolina IRP, Duke would need to add at least 1 gigawatt of solar per year through 2030, and maybe more, to reach the decarbonization goals of HB 951? Do you agree with that?
No, I don't necessarily agree with that because now I don't know if she's mixing Duke Energy Carolinas or Duke Energy Progress, or she's looking at the joint study case, which is generally just sort of a hypothetical because they are two independent BAs. I don't know if you can provide any more discretion on that because Duke Energy Progress has a magnitude greater. I don't know, I can't recite the exact numbers of solar generation above Duke Energy Carolinas.
Okay. I'll represent to you that Ms. Miller is, I believe, speaking collectively of the two utilities. Do those numbers sound right when considered in the context of both utilities?
I didn't have to know which portfolio because under portfolio A, no new solar generation. I believe I did file testimony on this, but no new solar generation was economically selected on portfolio A, respecting that at that point in time in the 2020 IRP, we did not have HB 951.
I need to give our court reporter a break. So how much longer do you anticipate questioning?
I would say, and I will try to trim it down, but I'd say I have about an hour left. I'll try to go a little, I will, if we have a break, I will try to trim that down to get.
Okay, well, and y'all also may need to talk about, I mean, we have to leave at 5, so look at other dates potentially that we can come back. So I think we've identified December 8th as a potential date. So if all the parties could discuss that date during the break, we're going to go off the record. We'll be back on at 4 p.m. Ms. Mitchell, are you ready? Okay, let's go back on the record. So it's my understanding that we're going to try to finish up by 5:30 today. If not, I see a long continuance, nothing in the next, let's say nothing in 2021. So let's give public staff plenty of time for rebuttal or reply. And go ahead and get started, Mr. Snowden.
Okay, Mr. Metz, I will make a deal with you. I'm going to try to get us out here as quickly as I can. I am going to try to avoid having to refer to documents. If you could help me with that, that'd be super great. Okay, so Mr. Metz, are you aware that Duke has taken the position in the IRP that achieving the carbon reduction targets of around 70% will require very substantial investments in the transmission grid?
In the 2020 IRP, there were general assumptions in the IRP process that made some assumptions on a 70% target with generic portfolios, but maybe not the cost optimal portfolios.
Okay, understood. That those were not highly granular transmission estimates, but that would you agree that at those very, very high level estimates, Duke was estimating on the order of $4+ billion for the 70% carbon reduction scenarios?
Subject check, yes.
Okay, thank you. So the public staff takes the position that investments in the transmission system should be evaluated through a comprehensive system planning process. Is that right?
Yes,
Okay, and you provided testimony to that effect in the Frisian Cpcn docket. Is that right?
correct.
Okay, and you provided that testimony in December 2019 or thereabouts?
Subject check.
Okay. When you provided that testimony in 2019, was there a comprehensive transmission planning process in North Carolina?
Well, the current utilities have their transmission planning, and then through the North Carolina Transmission Planning Collaborative that they look at, in my words, sort of immediate issues or imminent issues, and as well as potential policy changes or factors or functions that could increase efficiency through joint utility operation.
But the North Carolina Transmission Planning Collaborative is not a comprehensive transmission planning process of the kind you described in your testimony in Frisian, is it?
No, it would be a function to inform the process that I was specifying in testimony.
Okay, and as I think was testified to earlier, there was a colloquy between Mr. Levitas and Commissioner Clodfelter that for the most part, not exclusively, but for the most part, the collaborative looks at transmission work that's required to maintain reliability, right?
That is one function, and then there's two scenarios that can be submitted. I can't remember what the other one of them is, but the other is the policy. And the policy one is one which even the public staff initiated a public policy request on a portfolio similar to the 2020 IRP, sort of a all of the above approach, simplified, to evaluate the total transmission investment requirements needed across both utilities.
Okay, thank you. As you sit here today, there is not in existence a comprehensive transmission planning process for North Carolina, is there?
I mean, sitting here, I mean, the existing process that Duke Energy, as the transmission owner per NERC guidance and overseeing by CERC, does evaluate long-term planning, may be the nuance there, but there are processes in place which the utility does evaluate the transmission system. I can't specify that necessarily is that a 5-year horizon, 10-year horizon, or 40-year horizon.
Mm-hmm. Well, let me go back to what you previously testified to, and that's that investments in the transmission system should be evaluated through a comprehensive system planning process.
I agree.
Okay. So is there a comprehensive system planning process that globally looks at necessary investments in the transmission system?
As of today, it is not my understanding that when we're looking at an IRP over the generation assets over the next 40 years, there is not a all-inclusive planning collaborative.
Okay. And is North Carolina in the process of developing a comprehensive transmission planning process?
I believe the initiative or the policy request through the TAG or NCPTC is a step in that direction to help inform the Clean Power Plan.
Okay, but do you have any idea when such a process might be established?
No, I do not.
Okay, thank you. And is it the public staff's position that significant investments in the grid should await the advent of a comprehensive transmission planning process?
They don't necessarily have to be precluded.
Okay, thank you. So, Mr. Metz, the commission frequently grants CPCNs that have conditions, doesn't it?
Yes, public staff has even requested some conditions in some cases.
Do you think it's important for the conditions in a CPCN to have a clearly understandable meaning?
Yes,
Okay. And so you just mentioned a moment ago that the public staff frequently recommends the granting of CPCNs with conditions. Is that right?
that is correct. And as we go through some of those processes, they can be very challenging at times to try to think of every what if or iteration or possibility that may exist. But yes.
Okay, thank you. With regard to upgrade costs, what sort of conditions has the public staff recommended that the commission include in CPCNs?
I can't recite them off the top of my head. I believe there were some conditions in the most recent, when I say the most recent, was over the last year or 18 months on some of the EMP applications, given the fluid nature of the affected systems and the cost responsibility of certain merchant plants. Again, as we discussed earlier, that process is before appeal at the FERC.
Mm-hmm. Okay. Would you agree that sort of just at a high level, what those conditions have said is that if an applicant or a CPCN holder sees a significant increase in their upgrade costs, they need to report that back to the commission. Is that right?
Yes.
And the commission may reopen the CPCN if there is a significant change in cost. Is that right?
Yes.
But none of those conditions that have been imposed define what a significant increase in costs is, do they?
No, they do not. And that's part of the challenges.
Mm-hmm. So those conditions provide very little certainty to a certificate holder as to whether its CPCN might be revoked. Is that right? Might be revoked in the event of a change in upgrade costs.
That is correct.
Okay, so even if an applicant or a CPCN holder knows exactly what its upgrade costs are, it still doesn't really know or have any way of knowing whether the commission will revoke its CPCN, does it?
It's a possibility if circumstances change that the CPCN could be revoked for multiple factors, inclusive of cost, most of which would require speculation on my part for what would trigger the revocation.
Mm-hmm. Juno Solar's proposed condition also allows the CPCN to be revisited once upgrade costs are known, doesn't it?
Say that again, please.
The condition that Juno Solar has proposed for its CPCN would also allow its CPCN to be revisited once upgrade costs are known with more specificity, doesn't it?
That is one provision with the inclusion that the one determination provision at the execution of the IA.
Okay. Isn't the only difference between this proposed condition and the proposed condition that the conditions that the public staff has previously recommended that Juno's proposed condition provides specific guidance to the applicant as to the conditions under which its CPCN will be revoked?
I don't agree with that generalization. There are multiple factors unique in some of the specific EMP applications, and it would take some time to go down to its specifics and go through over in some cases, almost a year of the fluid nature of some of the conversation, discoveries, and testimony on multiple EMP dockets.
Well, the conditions that the public staff has recommended in those other dockets all look pretty similar, don't they?
Similar in some, with one of the concept being evaluating the affected system attributes, which that was based upon a snapshot in time, as we've learned and as I filed testimony for this commission, that has proven to be extremely problematic and challenging and changing.
So I just asked you a moment ago if you agreed whether Juno's proposed condition is just a variation on the condition that the commission, I'm sorry, that the public staff has already recommended with just additional specificity. And you disagreed with that, right?
General disagreements can make the variations open-ended. I mean, anything with a minute change is a variation, but not to be talking in circles with.
Okay. The public staff objects to the condition that's proposed by Juno here. Is that right?
That is correct.
Okay. And you discussed the public staff's objections in your direct testimony, don't you?
Yes, we believe until a completed facility study by the incumbent utility is completed, that we cannot provide a recommendation to the commission.
Okay. So I'd like you to please look at page 34 of your testimony, starting on line 5.
Page 34, line 5.
34, yes, starting at line 5. I'm sorry, I think I have the wrong, I apologize. I have the wrong page. Sorry, forgive me just a moment. I'm close to it. Okay, I'm sorry. It's page 33, line 5.
Page 33, line 5, I'm
Okay.
there.
Okay, we're starting a little before that. You say that the applicant's requested condition presents other problems. And then you say that the upcoming TCS will be the first of its kind for generating facilities in the Duke balancing areas. And the public staff is concerned that if the costs go over the predetermined conditional threshold, withdrawals and delays may occur while the commission rehears the CPCN application at the request of the applicant. Did I read that correctly?
That is correct. And for context, that was based upon a snapshot in time of which the applicant wanted the ability to, not putting words in the applicant's mouth, but challenge if it went over the $4 LCOT in part.
Okay. But this concern has been addressed by Juno's agreement that its CPCN will simply terminate if the LCOT goes over $400. I'm sorry, over $4. Is that right?
In part, especially to the withdrawals and may occur while the commission rehears the CPCN applications. Yes.
Okay. So withdrawal, these delays would not occur if the CPCN were simply terminated and there was no rehearing?
I'm having a hard time following you on that one.
Okay, well, you say here that withdrawals and delays may occur while the commission rehears the CPCN application at the request of the applicant, right?
Yes.
Okay, so that's not going to happen if the CPCN just terminates, right?
Because the applicant will not be back before the commission. Yes.
Okay, okay, thank you. And then further down the page, starting on line 12, you say that the public staff believes that the applicant is shifting risk from itself unjustly onto captive ratepayers based on a metric that can be greatly changed if the facility changes design or reduces its nameplate capacity prior to commercial operation or over the life of the project. Did I read that correctly?
Correct.
Okay, so what you're saying here is that there's a risk that the LCOT of the project could change later, even after the IA is issued, if the facility were to add a battery or reduce its nameplate capacity?
Correct.
Okay. But the facility would have to amend its CPCN to change its design, wouldn't it?
It would have to change to amend its design. And that's where it gets into the nuances of the provisions. But if for the applicant's request, if the termination provision is at the execution of the IA, the applicant can, after the IA, perform an amendment for any situation, which I specified in testimony. Some may even be outside of your control and may even be reasonable. But it would impact the overall LCOT calculation or the magnitude or any function thereof.
But if Juno were to change its design, and it would have to notify the commission of this in a way that reduced its LCOT, the commission would be free to take action based on that, wouldn't it?
The commission may exercise its discretion as it warrants.
Okay. So this would, the commission's ability to take action based on, well, is that? It would seem that Juneau's obligation to notify the commission of a change in facility design and the commission's ability, which we all agree to take action based on that, should resolve any concern that you've expressed right here, wouldn't it?
No, because I think I just specified before, if the contract, or if a provision is that the revocable provision terminates after the IA, changes may occur after the IA, which still impact either the magnitude, LCOT, or the potential upgrades. So that's what I was saying. Is you start going down these conditions, there's multiple iterations of which you have to consider in respect of the timeline and as they move through the TCS process as the applicant has requested in this. Conditions are challenging. They can be implemented, but they have pitfalls.
But Juneau has an obligation to notify the commission of a change to its design independent of any condition in the CPCN, doesn't it?
That is correct.
And don't the rules provide that the commission, upon receiving notice of a change in a facility, has the discretion to take such proceedings as it deems appropriate?
That is correct.
Okay, thank you. Mr. Metz, I want to talk just for a few minutes about FERC's crediting policy. Do you know what I'm referring to when I say that?
Generally familiar, yes.
Okay. Is it fair to say that the public staff does not agree with the crediting policy and believes it should be abrogated?
Say that again, please.
Is it fair to say that the public staff believes that FERC's crediting policy is inappropriate?
I think that requires a legal conclusion as a technical evaluation. I'm not weighing into FERC's crediting policy.
Okay.
I can just offer that, we have comments in the ENOPR docket that speak for themselves. That's sufficient to the commission.
Okay. Well, I want to talk about it a little bit, I guess. Well, Mr. Metz, are you familiar with the comments that the public staff has filed in FERC's ENOPR proceeding?
I do not have them memorized. I'm generally familiar that the public staff filed comments and reply comments.
Okay. And when we say the ENOPR proceeding, that is the advanced notice of proposed rulemaking on transmission policy. I forget the full name, but that is underway right now at FERC, right?
That is correct.
Okay. And are you aware that in the public staff's comments on the ENOPR, the public staff recommended that FERC do away with the crediting policy?
The public staff comments speak for themselves. If that's what they say, that's what they say.
Okay.
I would just offer that Mr. Metz did not participate very fully in the ENOPR dockets.
Okay. So Mr. Metz, you did not participate in developing the public staff's comments on the ENOPR?
That is correct.
Okay. Well, let me ask you this. To what extent is the possible application of the crediting policy driving the public staff's position on Juneau's Cpcn application?
I don't believe my testimony rejected the application or directly took discriminatory function towards the crediting policy. The FERC crediting policy is the FERC crediting policy.
Understood. But the public staff expresses concerns about the possibility that Juneau will incur upgrades that will be repaid by, in part, by Duke's ratepayers, right?
That is a function of the crediting policy, yes.
Okay, and that potential for repayment is an issue that you raise in your testimony, is it not?
Not the repayment mechanism in itself, but the nature of the upgrades and whether or not the DEP system needs those upgrades.
I'm going to object to this line of questioning. I think Mr. Metz testifies about impact to ratepayers of the reimbursement policy, but does not go into the merits of the policy itself.
Mr. Snowden?
Yes, ma'am. Oh,
Move on.
okay, thank you. All right. All right, well, I have no further questions. Thank you, Mr. Metz. Commissioner Duffley, I would move that our Juno cross-examination exhibits, let's see, we have 1 and 2 be moved into evidence.
Any objection? Without objection, that motion is allowed.
Thank you.
Redirect.
Mr. Mentz, I'll try to be quick. You participated fully in the Q reform stakeholder process. Is that correct?
Yes.
Would you say it's an accurate to say that the public staff largely took a backseat role in terms of any comments on milestones, penalties, timelines,
That is correct.
that it mostly left those discussions to the developers?
Yes, developers are having multiple conversations as the public staff has to be, at least I'm cognizant when I go into certain stakeholder groups, is that when the public staff speaks, sometimes it can have a chilling effect on the group because we don't necessarily come across as a stakeholder, but we're coming across as, in order for this to pass, this is what has to be incorporated. So we try to work through that. We work through that the best we can, but that was something in consideration explicitly in the Q reform process.
And largely the timelines affected the utility and interconnection customers and not so much the public staff's interests.
That is correct. Those were mutually agreed upon timelines between the stakeholders and the utility planners to perform studies. Stakeholders have enough time to make their decisions and to complete it within the windows that were agreed upon.
And to your knowledge, both the FERC filing and the North Carolina interconnection procedures Q reform filing by Duke make a commitment to report in 2 years after the transitional study cluster and after the first ISIS round on lessons learned and potential changes to both the LGIP and the NCIP.
That is correct. As with any new policy that gets not policy, if any new initiation like this takes place, there will be lessons learned. There could be improvements. There could be even the potential of improved efficiencies leveraged as we gain more knowledge.
These timelines aren't set in stone, basically.
The timelines aren't set in stone and can be modified in future cases.
And do you recall the public staff's interconnection comments on Duke's Q reform filing, reply comments submitted 8/31 that provided, that the public staff was concerned about the alignment of affected system studies?
Yes, the public staff brought that forward to the stakeholders and to the commission. And in my opinion, is just the larger stakeholder group did not want to further advance that potential concern. It could be for numerous reasons. It's required too much speculation on my part. However, that would be a FERC governed process through the affected systems and not NCIP. Other than NCIP has to reference to when the affected system is triggered, you need to go follow that procedure.
Presiding Commissioner Duffley, I would ask at this time that the commission take judicial notice of the public staff's reply comments filed on August 31st, 2020 in the interconnection docket E100 sub 101.
Without objection, we will take judicial notice.
Thank you. I wanted to clarify one quick question that you answered. You, in response to a question, you said that there were 2 FERC jurisdictional projects in the transition cluster in DEP.
That is correct. Those are 2 solar projects within DEP and FERC in North Carolina.
There are 3 other FERC battery projects, and that can be seen in this. This is previously today marked as public staff Miller Cross Exhibit number 1.
Yes, that is correct. I misspoke.
Page 9. You were asked earlier by Mr. Snowden, how are interconnection customers supposed to proceed forward when they have, essentially no guidance about what the commission will consider an appropriate LCOT or an appropriate magnitude of costs? Would you agree that the Frisian final order and discussion of the LBNL provided certain benchmarks that could be relied upon going forward?
Absolutely, I agree.
Back to the start of questioning, you were asked about the demonstration of need and when the public staff says the demonstration of need has been met, maybe has had some various, different, evolving iterations. Would you agree generally, though, that the demonstration of need needs to be balanced with costs and any other potential adverse impacts to ratepayers?
That is correct.
And would you say that it is appropriate to have a higher standard, a higher demonstration of need when adverse impacts to ratepayers are likely?
That is correct, because they need the ability to evaluate those adverse impacts to ratepayers.
As my colleague has any other redirect questions?
Yes, just a few. Mr. Metz, do you remember when Mr. Snowden was asking you about the Timber Mill Wind project and that the public staff found a need for the facility in EMP-118?
I remember the line of question, yes.
Yes. I'd move to introduce the testimony, the confidential testimony of Jeff Thomas in EMP-118 Sub-Zero into the record as public staff, Metz redirect confidential exhibit 1. I will not have to touch on any confidential information, but
that we don't have a confidentiality agreement with other parties in that. See the confidential in its entirety due to this proceeding, that's fine. We're not able to review it.
I can just take judicial notice of his testimony, of Mr. Thomas's testimony in this proceeding, and ask Mr. Metz the questions.
Do you have
We
objection?
would also object to taking judicial notice of filing. Is there a redacted version?
Yes, there is a redacted version on the in the file.
Possible to get a redacted version?
Excuse me?
Is it possible to get a redacted copy?
Yes, I can. I mean, I don't have one with me at this moment, but
Mr. Josie, do you want to take judicial notice of the redacted portion?
yes.
Any objection? So allowed.
Mr. Metz, do you have a copy of the testimony of Mr. Thomas in EMP 118 Sub-Zero?
I do.
Okay. And on page 9 of Mr. Thomas's testimony, the question starting on line 10, why is the facility needed? Do you see that?
I see it.
Yes, and the answer is, according to Timber Mill Wind, the facility is needed because of the North Carolina renewable energy. And he goes on to discuss why Timber Mill states that the facility is needed, not that the public staff found that there was need.
That is correct.
And on page 17, lines 3 and 4, Mr. Thomas does recommend approval of this facility, correct?
Yes.
And on page 12, line 9, Mr. Thomas states that Timber Mill Wind is solely responsible for 100% of the network upgrades, correct?
Is it page 9?
Yes, page 9.
That is correct.
Excuse me, that's page 12, line 9. Sorry about that. And then also on line 12 of page 9, Mr. Thomas states that as recently as February 26, 2021, PJM confirmed that Timber Mill Wind does not rely on any affected systems cost, correct?
You're losing me on the page numbers, but
Page 12, lines 12 through 14.
That is correct.
Okay. And as you just discussed with Ms. Cummings, when there are no costs borne by ratepayers to construct the facility, the analysis of the CPCN application and the need of the facility and the associated benefits require a different analysis than we are looking at in this proceeding here, correct?
That is correct.
Okay. And just one final line of questioning. On page 11, Mr. Thomas states that Timber Mill finalized its facility study in September of 2015. Is that correct?
That is correct.
And on page 3, does Mr. Thomas state that Timber Mill filed its CPCN application on June 14th, 2021?
That'd be after the completed facility study, yes.
Yes, almost 6 years after, correct?
Yes, that is correct.
No further questions.
All right, Mr. Metz, just a few for you. The two FERC jurisdictional projects that are identified in the transitional cluster report, you have that in front of you?
I do not.
I just.
I have it in front of me.
Okay. I'm looking at page 9 just to get you there quickly, but so one of those projects obviously is Juno. What's the other project? What can you tell me about the other project?
You're referencing the 69.9 megawatt project?
Yes.
That's, I believe that was discussed earlier. That was Fusion.
That is Frisian. And so in this project, what we're hearing, make sure I understand this correctly. We're hearing from the developer that it needs the CPCN to move forward. It needs the certainty of the CPCN to move forward with the various phases of the interconnection process it's now in. Have we heard anything? Has the public staff heard anything on the Frisian project that's similar, a similar argument from the Frisian project?
I have not.
Okay. Are you aware whether an entity associated with Frisian has made a filing similar to the filing made in this docket?
I would only look over to council. They might be involved in more conversations than me, but I am not cognizant of
You're
it.
not aware. Okay, that's all I needed to know. What line is it, to the extent that you know, Mr. Metz, what line has to be upgraded for the Juno project?
That information was not provided. We asked for that in discovery. There became a question of whether or not we could evaluate critical energy infrastructure and whether or not we had the clearance. Given the timeline, that we did not pursue that any further. Only thing I can add is that we see facility upgrades publicly through the PJM facility study and system impact study that have nothing to do per se with CEI.
But given all of that, you don't know what line has to be upgraded here?
I do not.
Is it possible that it was the same line that was involved with the Frisian interconnection?
I do not know.
Okay. Fair.
I mean, it is a possibility that it's not. These are in just whether it is in the southeast North Carolina, which is involved in many counties, given the topology of the transmission system, they are somewhat isolated from one another. We did have in discovery a Q&A that we asked from the applicant on the Frisian upgrades. I can find that if you want, or we can bring that to your attention in a late filed exhibit that asked the exact question about Frisian.
I would like that as a late file exhibit, the applicant's response to the data request, to the, help me, we've heard a lot today in testimony from the applicant about the consequences of upgrading this portion of the DEP transmission system, as it relates to requirements now set out in state law, et cetera. I know you've been here the whole time, you've heard it. What, Mr. Metz, just help me understand sort of engineering of all of this. So how does upgrading the line associated with this one facility unlock, solution to a catch-22?
Without taking the argument of catch-22, When we look at generation needs, available ampacity or room on the transmission system. So let's just simplify it and say, larger the wire, the more electricity that I can move through it, simplifying assumptions. That if load increases, it creates heat, and therefore I have to upsize the transmission line, yada, yada, yada. I need more generation. So generation is solving for load. And to the extent that you have excess generation, you need to reconfigure, in some cases, you need to reconfigure the electrical system to allow that excess generation to get to the parts of the system, so that way you don't have excess voltage or decrease or increase in voltage or increase and decrease in frequency, because the system has to balance. So when you're evaluating those configurations in the system at that given point in time, sometimes multiple projects can be impacting a single line. Sometimes it can be a sole project. It is based upon the configuration and sort of the resistances and impedances of the system at that snapshot.
Okay. So if there's a line associated with Juno that's upgraded, how does that single upgrade, or how do the upgrades associated with the project facilitate the interconnection of other projects? Does it necessarily mean that those projects are gonna have to interconnect to the same line? Or it's just fewer upgrades on the system in general that the next project has to conduct?
It's very complicated in nature. It's always, you sort of get to that tipping point. So we never want to build out the system in too much excess. So we continue to add in incremental amounts. It could be just under the unique circumstances of that change case or load case and transmission planning, that it was just enough energy in that unique configuration. So like, say, hypothetically, 2 projects never triggered it, but 3 projects did. Well, through the TCS process, we will assign the cost accordingly. But it's not to say that this project is going to be this, again, that I don't know the nature of the upgrades, so I don't want to speculate too much. It's unknown of how this would magically unlock the southeast part of the system. I have one project that's triggering, by the applicant studies, $13 million to $16 million studies over here in this part of the state. But I have another project that's a fraction of the size of Juno that triggered 200 million, whatever the final number was. It's hard to correlate those, and to me, it just doesn't make much sense that this sole 275 megawatt project is going to be the silver bullet to unlock all the upgrades.
Okay, I'm going to ask, I got 2 more questions for you. First one, I'm going to ask you to speculate. What does the inclusion of the battery in this facility do to upgrades that would have to be made on the system?
So with the assumption that the battery is DC connected, and therefore I don't have to look at it as a load, I'm not charging the battery off the AC line. Under that assumption is that typically when you look at energy output of a solar facility, you look at it as a generation profile. I forget the exact hours. Let's just call it 9 to 9, sunrise, sunset. Little caveats in the timeline. But then you look at its the transmission load portfolio, the coincident load over those timings. So where the battery starts introducing a unique caveat is saying, well, if the battery can discharge at any point in time because it's a merchant power generator, how does Duke Energy Progress, the transmission owner, need to evaluate that injection onto the system? Because you have to, as we've had comments before the commission, you need to evaluate the ramp of discharge and as well as the amplitude. And so the utility would need to evaluate those during different periods than the summer profile.
Okay. All right, last question for you. Talked a lot about the LCOT today. This is a, as proposed, 275 megawatts solar generating facility. I assume that, and you can tell me if I'm sort of thinking about this incorrectly, but the facility really can be downsized at any point in time prior to construction occurring. Is that a correct assumption? Like you could, the facility could be studied as 275, certificated as 275, but then could be constructed at a lower nameplate, a smaller nameplate capacity, a lesser nameplate capacity. Is that correct?
That is correct.
Does that happen frequently?
Well, based upon SP applications, I would say yes, but I don't have that quantified as a percentage of change.
And that's fair, but just in your experience, that does happen.
Yes, it does happen. Sometimes it's actually to the benefit. If a facility was triggering upgrades, they could actually reduce it and say, oh, 223, again, hypothetical, is the magic number. Go to 223. Other times you can get into an operating agreement to say, well, we're having challenges on the system on July between 2 p.m. and 3 p.m., again, being somewhat facetious. You downrate for that given hour when we call upon you to go down to 100 megawatts and not 275. That'll save you $50 million in upgrade cost if you agree to that in operating agreement. Those great, I wouldn't say challenges, but operating agreements are another provision that could be utilized in the event once potential impacts or triggers are known.
Are you aware of whether there are any operating agreements in existence as of today between either of the Dukes and a third-party generator?
I've only had conversations and concept of operating agreements that can exist. There's one unique operating agreement with Dominion and PJM under certain configurations of the transmission system for the Greensville combined cycle plant, to the best of my knowledge.
Okay, but with respect to third-party solar, QF solar, you're not aware of an operating agreement?
That is correct.
Okay. All right, that's all I have. Thank you, Mr. Metz. I appreciate your testimony.
Thank you.
Mr. Metz, just one follow-up on this operating agreement. Would you need to go through the facility study process to be able to determine a proper operating agreement? At what point in the process?
I don't have an exact answer to that. To be fair, to be honest, I don't know when that could be implemented. My assumption from an engineering perspective, I would need to know what the upgrades are, or basically what are the overloads. Once I identify the overloads and the time period of those overloads, I can be able to tell you when you need to curtail the percentage of curtailment. And that would be an informed decision that the applicant can make to say, well, really, can we curtail or not operate? Is it economical, or is it better? Is it more economical to go ahead and pay for the upgrades? What's the cost benefit on either scenario?
Okay, thank you. Commissioner Clodfelter?
Mr. Metz, we've been told that we need to take into consideration the risk that if we do not grant this conditional CN request, that the transitional cluster study process may possibly implode. When I look at Public Staff Miller Cross-Examination Exhibit 1, I can see that there are 6 projects that will propose to interconnect at the transmission level that are large enough to require Cpcns in South Carolina. 2 of those are FERC jurisdictional projects interconnection, one 165 megawatts and one 150 megawatts. By any remote chance, do you have any information as to whether any of those 6 projects, especially the 2 that are FERC jurisdictional, have obtained or have requested Cpcns in South Carolina?
I do not know at this time, Commissioner Clodfelter.
Thank you.
I wanted to follow up with something that you stated with respect to comprehensive transmission planning. Do you not consider the North Carolina Transmission Planning Collaborative a proper vehicle for comprehensive transmission planning?
I do, and I thought I tried to clarify it, so if I said that incorrectly, that was not meant to come across that way. I believe that certain policy initiatives of which the planning collaborative can evaluate, if structured in such a way, can be a vehicle to inform the overall, either sort of like the transmission process or inform sort of the IRP to how to incorporate the sort of the rate impact or the transition to go to these potential portfolios and do it in a form process versus a post-processing analysis in the IRP.
Okay, thank you for that. And Ms. Miller's testimony indicated the upgrades for the Juno project will be minimal. Could you speak to that issue or that testimony?
The overall application and through discovery, I believe they listed as their identified upgrade costs are 13 million with their assigned cost, or worst case, if their assigned all cost is 16.84 million for approximately, I believe it was 17 miles of some type of rebuild. I evaluated that on both in my testimony, sort of the overall LCOT impact, which would be approximately $1.34, give or take. And then I also provided with the commission in table 2 is the rate impact of those lower dollar values.
Okay.
And that's in METS table 2 if you were trying to reference it.
Okay, thank you. And then going to the Public Staff Miller Cross Exhibit number 1 on page 9, in the last column, it says percentage study cost depth. And so how is that determined, if you know?
It is my understanding, I haven't checked the math, but that should be a simple ratio. You take up the sum of the megawatts and just apply their pro rata share. So let's just say I had 1,000 megawatts. If 1.08 was their share, the math understands dangerous, but 108 megawatts. No,
Okay,
less than that. No, that's right. Sorry.
thank you. Questions on commission questions?
Yes, ma'am, we have just a few. I will start at the end. Mr. Metz, this follows on, Chair Mitchell had some questions about the downsizing of the project.
Yes.
Isn't it the case that if a FERC jurisdictional project downsizes by more than 10%, that triggers a material modification under the LGIP?
That's my general understanding.
Okay, and that requires a restudy of the project, doesn't it?
The LGI, yes, that is my understanding.
Okay. Chair Mitchell also asked you a few questions about the potential upgrades that were identified for Juno in relation to the upgrades, the Frisian upgrades that were discussed in the Frisian proceeding. Do you recall that?
Yes.
Would you agree that there are a lot fewer megawatts in the queue or in the transitional cluster now than there were when the Frisian upgrades were studied?
That's true, but I don't see the correlation of that to the Frisian upgrades. I mean, the Frisian upgrades were the cost causer or the tipping point of the overall system at that point in time.
Understood that they were the first to cause that specific overload. Is that right?
That's correct.
Okay. But the baseline for Frisian study included a lot of megawatts of projects which may or may not be still in the interconnection process. Is that right?
I can't agree to that, no.
Well, do you disagree with that, or you just have no basis for agreeing or disagreeing?
I have no basis disagreeing. To agree or disagree is just my general understanding of the base case would not assume that I forget what the numbers are. I'm not going to start spitting out thousands of megawatts. Should not have been in the base case. It had to be at that point in time my general understanding is that at that point in time when the system is studied, it is a future look, but it's not based upon other, specifically to Frisian, it's not speculative SPs that have not interconnected with the utility, but the utility would factor in known upgrades that are taking place for already existing service.
Well, wouldn't you agree that all higher queued interconnection customers would have been considered in the baseline for Frisian when it was studied?
In relation to some, I can't answer that because now I'm trying to draw the correlation between the FERC queue and the state queue. And when Frisian was jumping back and not jumping back and forth, but they originally were a state queue project and then transitioned over to the FERC queue.
Understood. But when Duke studies projects in the serial process, it treats, from a study standpoint, it treats FERC jurisdictional and state jurisdictional projects on equal footing, right? They're in a single queue for purposes of study, aren't they?
I believe that's correct.
Okay, so would you agree that the baseline, so to speak, for the Frisian interconnection studies would have included every prior queued project, whether it was state or FERC jurisdictional at that time?
I don't know the answer to that at this point in time.
Okay. And I'm just trying to sort of, what I'm getting at here is understanding why the Juno upgrades are so different from the Frisian upgrades. So what I heard you say is that you would neither agree nor disagree with the possibility that a lot of projects falling out of the queue as they went into the transitional cluster might be partially responsible for the different study results for Juno than for Frisian.
That is possible. As we also had in discovery, which I believe has been provided to the commission, is what was the base case for the Juno application, and the base case was the cluster study at that particular point in time, or the cluster or the FERC queue at that particular point in time. And as we already know, is that the transitional serial cluster process that will be studied is actually much different now than the queue was when the applicant evaluated the project. And some of the interrelation relationships that start to occur when you start looking at power flow analysis, it's the possibility, again, under hypotheticals, is that if you put a facility on this line on this part of the system, put a facility on this line on this part of the system, in some unique circumstances, the power flows could butt one another and the power could go into different parts of the system. So the moment that you start retiring plants, removing plants, in this example, I'm saying sort of like Duke Energy Carolinas and Duke Energy Progress, power flows change. Is this a snapshot in time under those unique facts and circumstances? And I don't know what was evaluated. The only thing I can say is the TCS where we're at right now is a lot different than what we understood in discovery.
Okay. Understood. And the TCS, as we look at it right now, is a lot different than what the queue looked like when Frisian was evaluated, right?
That's correct.
Okay. Are you familiar with the interconnection settlement between Duke Energy, various settling developers that was filed with this commission back in September 2020? Generally familiar with it?
I'm generally familiar. For some reason, I think there's multiple settlements.
Okay. Do you recall, Mr. Metz, that there was a provision of that settlement that allowed certain distribution projects to be curtailed during high congestion periods so that they could interconnect in congested areas?
I'm generally familiar with that
Okay.
case.
And do you think that Duke's ability to curtail those projects may have, to some extent, alleviated some of the upgrades that were originally assigned to Frisian?
Unknown. I don't know if in Duke's study, if they would actually evaluate or call on those curtailments. It would be speculation.
Understood. Thank you. So you talked just a little bit about the Timber Mill wind proceeding, and Mr. Josie asked you, you pointed out that the public staff didn't explicitly support Timber Mill Wind's assertion of need. It simply didn't oppose it. Is that correct?
I think testimony speaks for itself.
Okay. But the public staff did support approval of Timber Mill Wind's application, did it not?
That's correct.
Okay. And it would only have done so if it agreed that Timber Mill Wind had met the statutory standard for getting a CPCN, right?
It's an elastic standard given the unique facts and circumstances of the specific case at that time. The public staff viewed the circumstances for Timber Mill warranted approval of the CPCN.
Okay. But at least implicitly, the public staff supported Timber Mill Wind's assertion that there was a need for the project. Is that right?
I don't know. I can say that's implicitly the public staff supported the approval of the application.
Okay. You also testified in response to Mr. Josie's question that where there are.
Excuse me. Keep in mind, these are questions on commission
I'm
questions.
sorry. I apologize. Yeah, this was recross. So those are all of my questions. Thank you.
Just one question in response to Chair Mitchell's questions about downsizing. Do you have a copy of Public Staff Levitas Cross Exhibit number 1, which is the large generator interconnection procedures?
Yes.
On the definition section, on page 6, there's a definition of material modification. Do you see that?
Yes, I do.
And it states that in regard to the definitive interconnection study process, as opposed to a serial process, that modifications that have a material impact on the cost or timing of any interconnection request with a later queue position or a queue position which is included in the same cluster. So it has to, material modification has to impact another project. Do you agree with that?
I would agree, yes.
And if you turn to page 32, this is the bottom of page 32, section 5.4.1.
I'm there.
There's specific provisions regarding material modifications prior to system impact study. And that includes a decrease of up to 60% in the electrical output of the facility.
Yes, with, as you noted, with prior to system impact study agreement.
Right. And 5.4.2, material modifications prior to facility study, which includes an additional 15% decrease in electrical output. Do you see that?
I see that.
That's all. Thank you.
Chair Mitchell, you had one more question.
I did, but Mr. Matz answered it, so no more questions for me.
Okay, it looks like we've come to the end of the day. Thank you, Mr. Matz. We all appreciate your testimony today. You step down. One housekeeping matter, Mr. Snowden, I only have one
Yes.
Juno Metz cross.
Yes, ma'am. I was in error. We handed out 2 more exhibits, but I did not ask them to be identified. So I would only ask that exhibit Juno Cross Exhibit Metz 1 be into the record.
Okay, without objection.
And can I move witness Metz's 2 exhibits from his pre-filed testimony into the record?
Without objection, both motions are allowed. Okay, are there any other matters? Housekeeping matters. Okay, proposed orders will be due 30 days from the receipt of the transcript. I will hold the record open for potential additional evidence and will issue an order in the future closing the record. We are adjourned.